parallel 249/15. Accused in custody 12 years, my lord, for bail.
I filed a petition for interim bail. Let it come tomorrow.
Interim in criminal
Family necessity.
There was with the case of regulations in 2014 lawsuit.
Hmm?
The present Ratho lawsuit struggling for regulation since 2014 lawsuit. Read the case of 2020 lawsuit by the state lawsuit.
It is our assignment.
Lawsuit.
All right, give it.
Retired since 2012.
Mhm.
RSCP and pension matter. 2019 case. I have mentioned earlier, it does not count.
All right, please.
My lord, matter arising out of a order of Honorable Orient. Actually, my lord, this is a read petition. This is not maintainable.
Honorable?
And in
Honorable OEM.
they have filed a read petition. I am the opposite party in the case.
Orissa State of Orissa State.
Odisha Real Estate Appellate
Real
Tribunal.
Estate.
Orient, my lord. Orient.
Okay, yes, tribunal.
No, actually, they filed a writ and obtained a stay. But writ is not maintainable against the order of Honorable Orient. So, my lord, since 1 year that building has though completed, they are not giving possession to me. I am
Have you
unnecessarily.
filed an application for vacation of stay?
My lord, of file.
Give it.
Oh, please.
My lord, in this case, Union of India is the petitioner. I am the opposite party, my lord. He took 5 time, my lord, for filing reply affidavit, my lord. The lawsuit posted 17 to 2025. They are not disturbed.
It's a fresh admission land acquisition matter, your lordship.
My lordship, one CRL 164/2029. And my lord, you time is surrender kurji, my lord.
Wait,
On bail, interim bail.
New provision.
My lord, the appellant's grandmother was died on 28/2/2025. So I pray for tomorrow interim bail, my lord.
You do one thing. Yeah. You give a copy of that interim application to the state. Who is there? Just verify it so that IAC grandmother expired on 28/2. So,
My lord, another matter, my lord, I am the petitioner against the order of CAT, my lord. This matter was posted on 27/6/2024. Thereafter, not listed, my lord.
My lordship, the petitioner is in jail for more than 12 years.
Okay. Bail matter.
Maternal grandmother, Mr. Naik, bujive.
Okay.
One CRL.
A land acquisition matter where at the stage of fresh admission, the state appeared and filed a counter, for which reason your lordship posted the case for hearing instead of passing any interim order. Now, this matter was in the list on 5/11/2024 before the reasonable court. Since the state councils had joined recently, they took time and the matter was directed to be listed in week commencing 18th of November 2024.
They are not listed.
No, not listed. Last week I made a mention. Your lordship was pleased to allow the memo, and there is a court slip in place saying that the matter will be listed this week, next week. Now the list section says, since no date has been fixed, it is next week, it will not be listed. I think my engaging counsel also impressed upon the courtmaster that and brought it to the notice of the courtmaster. And despite that, it is not being listed.
Yes.
My lord, one CRL 164/2029. My lord, appellant was interim bail. They surrender in due time. My lord, the case may be 302 or 34 IPC.
You filed memo.
Memo my lord file कर दीजिए 10 तारीख को. Online memo. Number है 383 my lord.
It's all right.
We can list item number 1.
Please, this is an appeal challenging the order dated 29/11/2021 of the Honorable Single Judge in WPC OEC number 690 of 2013. That's for ease of reference, my lords. I have made a small date chart. I've given it to the courtmaster, my lord. The petitioner was appointed on 14/8/2084, and the respondent was appointed on ad hoc basis as trained graduate teacher in Rengali Subject Higher Secondary School in a postgraduate teacher post. On 13/6/91, she was transferred to teach at Rengali Project College. On 13/4/94, the post was redesignated as junior lecturer post, and the pay attached to the post of junior lecturer with effect from 1/4/94 was given to the respondent. On 28/8/2009, by virtue of a government order, one Kanchanwala Satpathy, who had joined along with the respondent, was allowed postgraduate teacher scale by government order with effects from 15/8/84 to 36/91, and junior lecturer scale with effect from 17/91 to 6/9/94. But this benefit was given to Mr. Kanchanwala Satpathy only when he filed an OA number 1251 of 1990. That was allowed by the tribunal by order dated 16/11/98. The state, my lords, challenged this order in WPC number 1397 of 2005 that was dismissed. The state preferred an SLP challenging the order of the Honorable Court that was dismissed on 27/4/2009. After this, the order of the tribunal became final and she was granted the benefits. After Mrs. Kanchanwala Satpathy was granted the benefits, on 9/9/2009, the respondent filed a representation to grant her similar benefits as that of Kanchanwala Satpathy after coming to know of the order dated 28/8/2009. That representation, my lord, will find at annexure 6, page 22 of the writ petition.
Now, how do you say it is after 25 years?
Because he joined in 84.
No, that's all right. But the relief which was granted to Kanchan Bala, that was on 28/8/2009.
My lord. See,
So, and within 12 days, she has filed the representation.
Yes, my lord.
So,
my point, in fact, what I will present before my lords is that she waited until Mrs. Kanchanwala Satpathy got her relief. After
can that be a ground to deny the both of them are standing on the same footing?
There is law in that point. I'll give that law to my lords. My lords must now come to the important order.
You granted the relief to that Kanchan Bala on 28/8/2009. Right?
My lord.
And she filed the representation just within 12 days.
My lord.
And also filed the original application before the central or state administrative tribunal.
State administrative.
State administrative tribunal in March 2010 because you did not dispose of the representation.
No,
so they,
yes.
Right. Then a representation was rejected in 12. So you are pointing out the laches on the part of that lady, this respondent. You are forgetting that once this Kanchanwala, you are not disputing that Kanchanwala Satpathy and the present respondent, they joined on the same day. They stand on the similar footing. So Kanchanwala has got the relief. So why you are depriving of a lady in getting that because she waited from 28/8/2009 to 9/9/2000.
That point, my lords, I'll say. What I am trying to put before my lords is the law on the point. My lords, kindly have a look at the judgment.
That will do, but one thing, your date chart is not very clear. That 28/8/2009. That date.
That is the date on which Mrs. Kanchanwala Satpathy was given the benefit by the government.
Yes, that was the.
But before that, you have to give the dates because government has given her. Thereafter, her OA has been allowed. Those dates are necessary.
What I've done.
You come to the.
Summary is fine, but the dates are required.
You come to that order of the single judge, learned single judge.
Paragraph 7.
What is that page?
My lord, this is page number 25 of the appealment.
25 to what one?
Para 7.
Just a minute.
21.
25.
It starts from 21.
It starts from 21. The operative portion is page 25, para 7.
No, you come to that now. The factual background.
No.
You come to that paragraph number 4.
Ma'am, I'll please, ma'am.
Yes, the judgment, the order of the single judge dated 29/11/2021.
Okay.
Paragraph 4, and it is page number 23.
Ma'am.
Right?
Ma'am.
So paragraph 4 contention the okay.
Mr. S. Patra, learned counsel for the petitioner, contended.
Just a minute. Yes.
23.
Page 20, single bench.
Yes, yes.
Paragraph number 4.
Oh, my
Please.
Mr. S. Patra, learned counsel for the petitioner, contended that the government of Odisha Irrigation and Power Department, by letter dated 4/2/1984, directed for creation of posts for the upgraded Ringali Project High School to the higher secondary stage.
Yes.
The petitioner was appointed as a trained graduate teacher at Ringali Project Higher Secondary School in the pay scale of rupees 410 to 840 gains a sanctioned post on ad hoc basis on 14/8/1984.
Same day that Kanchanbala was also. Yes.
Thereafter, the petitioner, along with others, was transferred to teach at newly created Rengali Project College on 13/6/1991.
That was also Kanchanbala also went there. Right.
Such teachers were redesignated as junior lecturers and allowed the pay attached to that post of junior lecturers with effect from 1/4/94, wide order dated 13/4/1994.
Okay.
As a result of which, the chief engineer, wide order dated 6/9/94, redesignated the petitioner as junior lecturer and he was continuing in the said post.
Right.
One Kanchanbala Satpathy was appointed along with the petitioner, was allowed the scale of pay of postgraduate teacher with effect from 1984 by government order dated 28/8/2009. Therefore, the petitioner submitted his representation on 9/9/2009 before the opposite party number 1 for allowing the same benefit as has been given to Kanchanbala Satpathy.
So you see the date, two dates different. The government order in favor of Kanchanbala was passed on 28/8/2009. Right? There is no dispute.
No dispute.
And your case is also that they are similarly situated. They transferred to Rengali Project College, and they were also redesignated as junior lecturers, and they were also allowed the pay as to the junior lecture, both of them, from 1/4/1995, and the order was passed on 13/4/1995. So then Kanchanbala got the government order on 28/8/2009. This lady, this respondent, submitted the representation on 9/9/2009. So it is just 12 days after the government order was passed in favor of Kanchanbala. Now, you did not take any action, or you just continue there.
Since no action was taken, the petitioner approached the tribunal by filing OA number.
Petitioner means respondent.
Respondent,
yes.
Approached the tribunal by filing OA number 781C of 2010, which was disposed of by the tribunal with a direction to consider the representation of the petitioner on merit. But the same was rejected on the ground that he had approached the tribunal at a belated stage, while the impugned order dated 5/11/2012 under Annexure 8.
So you have given the date. He approached the tribunal on 26/3/2010. Right? She submitted the representation on 9/9/2009, and you did not dispose of the representation. That is why maybe within 6 months she approached the tribunal, and the ground then the representation direction was given to dispose of the representation on merit, and you rejected the representation on the ground that she approached the tribunal at a belated stage. What is the belated stage?
In service jurisprudence, this petition, the respondent, is known as a fence sitter. The fence sitters, my lord, there is a specific law. My lord,
yes.
May kindly have a look at the judgment. Lord, my first page, my lord, 347. The facts I will place, because that is relevant. First page of that judgment, paragraph G. Sometime in the year 1986, certain posts of homeopathic compounder and ward boys were advertised. The respondents applied.
No, we did not get it. Paragraph
First page, my lord, subparagraph G.
First paragraph means it starts in page number 350.
347.
347. No, you come to that decision. Come to the.
Then I'll take to the operative portion, the last page.
No, maybe the factual maybe little different. So
fact about it.
you come to paragraph number 2 of the judgment.
Well, to mention at the outset, the tribunal as well as the High Court has given the respondents herein benefit of the order passed by the court in earlier round of litigation filed by similarly situated persons. The appellants contend that as far as these respondents are concerned, they never approached the court seeking such a relief and were only fence sitters. And therefore, relief should not have been granted to them even if they were similarly situated as those persons who have been granted relief in the petitions filed by them. The respondents, on the other hand, contend that once it is found that both sets of persons are identically placed, the impugned orders granting them the same benefit are in tune with the constitutional mandate enshrined in Article 14 of the Constitution of India. After that, both parties, my lords, have given judgments for and against. And after perusing all those judgments, my lords, they have the last page, they have summarized the proposition of law. This is at paragraph 22. Last page, my lords, 363. 363, my lords, the last page.
22.3.
22. I'll read that.
All right.
The legal principles which emerge from the reading of the aforesaid judgment cited both by the appellants as well as the respondents can be summed up as under. The normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending the benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. This principle needs to be applied in service matters more emphatically as the service jurisprudence evolved by this court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not to be treated differently. However, this principle is subject to well-recognized exceptions in the form of laches and delays as well as acquisitions. Those persons who did not challenge the wrongful action in their cases and acquiesced into the same and woke up after long delay only because of the reason that their counterparts who had approached the court earlier in time succeeded in their efforts, then such employees cannot claim the benefit of the judgment rendered in the case of similarly situated persons be extended to them. They would be treated as fence sitters and laches and delays and or the acquisitions would be a valid ground to dismiss their claim. However, this exception may not apply in those cases where the judgment pronounced by the court was judgment in rem with intention to give benefit to all similarly situated persons, whether they approach the court or not. With such a pronouncement, the obligation is cast upon the authorities to itself extend the benefit thereof to all similarly situated persons. Such a situation can occur when the subject matter of the decision touches upon the policy matters, like scheme of regularization and the like, see C.K.Sahoo versus Union of India. On the other hand, if the judgment of the court was in personam, holding that benefit of the said judgment shall accrue to the parties before the court, and such an intention is stated expressly in the judgment, or it can be impliedly found out from the tenor and language of the judgment, those who want to get the benefit of the said judgment extended to them shall have to satisfy that their petition does not suffer from either laches and delays or acquisitions. My humble submission, my
read out paragraph 23.
Viewed from this angle, in the present case, we find that the selection process took place in the year 1986. Appointment orders were issued in the year 1987, but were cancelled by orders dated 22/6/1987. The respondents before us did not challenge these cancellation orders till the year 1996, that is for a period of 9 years. It means that they had accepted the cancellation of their appointments. They woke up in the year 1996 only after finding that some other persons whose appointment orders were also cancelled got the relief. By that time, 9 years had passed. The earlier judgment had granted the relief to the parties before the court. It would also be pertinent to highlight that these respondents have not joined service nor working like the employees who succeeded in earlier case before the tribunal. As of today, 27 years have passed after the issuance of
it's a totally factually it is different. You see, some persons approached, so it might be that those posts were also filled out. So there is nothing left to the other persons. But here is a case of monetary benefit, right? The particular scale of pay is to be granted, and negligent is in your fault. Okay, and it is a continuous wrong which has been committed on the respondent. Because she submitted the representation, you delayed the matter. It was your duty that when a similarly situated person has been granted relief, they both of them joined together, qualification same, both of them were transferred to one place, given the same post, they were discharging their duties. One man has been given. So how, when the representation was filed, it is the state who is like an employer. It is said that a noble employer, and you should see that the other person, you should not fight in tooth and nail with a lady who is getting just 400 from 1984, or he is in service, and what fault she has committed. She filed the representation within 12 days of the the employee got the benefit, and you delayed the matter. She approached immediately approached the tribunal. Tribunal passed the order. You dispose of the representation. Then you rejected that. You approach the tribunal on the ground. So see, देखिए से decision पे see this. This is the case of party name is Tukaram Kana Joshi versus MIDC 2013 1 SCC 353. 2013 1 SCC 353. Tukaram Kana Joshi and others. The paragraph 12, few lines. Delay and laches is adopted as a mode of discretion to decline exercise of jurisdiction to grant relief. There is another facet. The court is required to exercise judicial discretion. The said discretion is dependent on facts and circumstances of the cases. Delay and laches is one of the facets to deny exercise of discretion. It is not an absolute impediment. There can be mitigating factors, continuity of cause, action, etc. That apart, if the whole thing sucks the judicial conscience, then the court should exercise the discretion, more so when no third party interest is involved. Thus analyzed, the petition is not hid by the doctrine of delay and laches, as the same is not constitutional limitation. The cause of action is continuous, and further, the situation certainly shocks the judicial conscience. Then the next paragraph number 14. Discretion must be exercised judiciously and reasonably. In the event that the claim made by the appellant is legally sustainable, delay should be condoned. In other words, where circumstances justifying the conduct exist, the illegality which is manifest cannot be sustained on the ground of laches. When substantial justice and technical considerations are pitted against each other, the cause of substantial justice deserves to be preferred. For the other side cannot claim to have a vested right in injustice being done because of a non-deliberate delay. The court should not harm innocent parties if their rights have in fact emerged by delay on the part of the petition. So this is the proposition. Now you see that you can say that the other party approached the court, that original application in the tribunal C file, but ultimately the relief was granted to him on 28/8/2009. And your date chart also indicates that within 12 days he filed the representation. And you are not disputing that. Was also your contention in this before the single judge. Your contention has been noted down that You come to that paragraph number 7 of the learned single judge order.
Having heard learned counsel for the parties and after going through the record, it is evident that the petitioner was rendering his service along with Kanchan Bala Satpathy, and the benefit has been extended to the said Kanchan Bala Satpathy, who is similarly situated with that of the petitioner. Said Kanchan Bala Satpathy had filed OA number 1251 of 1990 before the Odisha Administrative Tribunal, Cuttack Bench, Cuttack, for regularization of a service as a postgraduate teacher from the date of joining, that is 28/8/1984. The tribunal, by order dated 16/11/1998, disposed of the said original application with a direction to pay the salary to her at the maximum of the scale attached to the post of postgraduate teachers in a higher secondary school as received from time to time with effect from 14/8/1984 until 36/1991, and for the period from 1/7/1991 to 6/9/94 to pay the minimum of the scale attached to the junior lecturer in a +2 government college. Thereby, the tribunal has made it clear that authorizing the higher scale to the petitioner was clearly on the principle of equal pay for equal work, which should not be constituted as amounting to conferring gazetted status on her if the appointment as a junior lecturer has not been concurred by the OPSC. Her regular appointment in that post or in the post of PG teacher shall count only from the date of such appointment is concurred by the Commission. Against the order dated 16/11/1998, passed in OA number 1251 of 1990, the state filed WPC number 1397 of 2005. This court dismissed the writ petition by order dated 23/9/2008, which was challenged by the state before the Apex Court in SLPC CC 5167 of 2009. The same has been dismissed by order dated 27/4/2009. Consequence thereof, Kanchan Bala Satpathy received the benefit of PG teacher from the date of joining till 36/1991, and then the scale of junior lecturer from 1/7/1991 to 31/3/1994 by order dated 28/8/2009 of the Chief Engineer and DM Brahmani Left Basin, Samar. Rejection of the claim of the petitioner on the ground that the petitioner has approached the tribunal at a belated stage that will not stand in the way, as the similarly situated employee has already been extended the benefit. Thereby, the petitioner stands on the same footing. The authorities should have extended such benefit to the petitioner. Rather, they have rejected her application on the flimsy ground that she has approached the tribunal at a belated stage. If the rights of a person is being affected and he has been discriminated, he has every right to approach the appropriate forum. Therefore, the tribunal directed to consider a representation taking into account the order passed in the case of Kanchan Bala Satpathy. But while passing the order impugned, reasons for not extending the benefit is only indicated that she had approached the tribunal at a belated stage. That itself is not the ground not to extend the benefit to the petitioner, because she stands on the same footing as that of Kanchan Bala Satpathy, to whom the benefit has already been extended. Thereby, non-extension of such benefits is in violation of Article 14 of the Constitution of India. In view of such position, the order dated 5/11/2012 under Annexure 8, passed refusing to grant the benefit to the petitioner, is hereby quashed, and the opposite parties are directed to pay such benefits to the petitioner at par with Kanchan Bala Satpathy in terms of the direction given by the tribunal in the case of Kanchan Bala Satpathy to the petitioner as expeditiously as possible, preferably within a period of 4 months from the date of commendation of the order.
So, how much money you are further required to pay if, in terms of the order which has been passed in favor of Kanchan Bala Satpathy? That is also to be a question of substantial justice. They were doing the same duty. They are two ladies, qualification same date appointment, same day transfer, same day they. State should come up with a case where.
My lord, what is happening? In fact, there were not two; there were 11 of them joined in the same post or similarly situated.
Before us, this case is there.
There was another case, my lord. Since the tribunal's order, my lords, is also not consistent, because this is one view. My lord would see I have filed an affidavit dated 10/6/2024 in this writ appeal. Another case, my lord, may kindly have a look at that. Page 15 of that affidavit, my lords, dated 10/6/2024.
This ideal employer is a man who just. How much money?
A few lakhs.
Huh?
It's a lot.
Maybe 1 lakh.
What?
and she is in service since
1984.
1984. We are in.
I am only, my lords, presenting a point of law. My lords to accept.
That is also to be seen.
Absolutely.
You, sometimes long period of that acquittal order, let us say.
Yeah.
Why we don't interfere? So many things. So it's a matter of 1 lakh rupees and lady. So you are giving so much of benefit to the ladies. So much scheme has been formulated, and the teacher will be deprived of just she has, the only fault she has committed that she should have approached simultaneously. Otherwise, there is nothing.
Why I am inviting my attention is that there is a disparate view also of the same tribunal in a similar case.
Yeah.
That order I am just bringing to my lord's notice. In that additional affidavit, my lords, at page 15.
Page 15. Yes, sir.
This is one Dilip Kumar Naik, also similarly situated as that of this respondent. And he had approached the tribunal in the year 1990. And the 1998 order of the tribunal, that is what I am trying to place. My lords will come to that?
No, it was dismissed. He might have approached this court thereafter. Whether this court has also turned down the prayer. Because in your case, the High Court confirmed, Supreme Court confirmed. Suppose thereafter this order has been passed, because he can challenge the order and take the ground that this order has. So
I have no instructions to challenge it.
Nobody should find out. If one person gets relief, we should also grant relief to the others. Why should they be deprived?
On the same ground that
yes.
What I am trying to say is,
you before the learned single judge, you fairly submitted that both these stand on the same footing. Only ground that she approached the tribunal.
My entire submission, my lord.
Just one moment.
Other cases, writ appeal pending.
Writ appeal, writ petition, you find out because.
We can see that. Otherwise,
you are saying a tribunal did not have a uniform approach. We can have.
Suppose, let us say,
whatever.
This order which you are pointing out, Dilip Kumar Naik, your case is that he is also similarly situated.
Similar, same.
So, suppose.
You don't know what happened thereafter.
Do not know. So,
Mr. Patra, do you have any idea what happened to the others?
No. So far, 6% have filed simultaneously. 5% have been given benefit.
Very good. Give that. That will also.
Which case?
Along with the petition, another 4% are there.
Are they pending or?
Another 4.
No, the other cases, they've already been granted pursuant to order of this court, or?
Other cases were disposed of second time in tribunal. These cases.
Very good. Please give that. बढ़िया है करते अलगा गोटे को घर रखी देला बस
अरे दे
persons appointed 11. He says that 5 has already granted
4%.
Why don't you give us that with an affidavit or a memo so that it will be helpful?
The benefit has been given. That order I have not. But the order passed by the tribunal is with me.
No, order tribunal in the favor of the.
Yes.
They will say whether that has been challenged or not.
That has been challenged or not. So those persons.
Along with the memo also give, or affidavit would be better so that he can verify you also give. If one has got, everybody will get. Then we understand. You are doing it as your duty.
And the appellant rejected the case, relying on overruled judgment. Which is related to reservation. That Ajit Singh case.
No,
that has been rejected.
The decision he has given that has a bearing.
Another thing, what they said in the writ of appeal, no opportunity was given to file the counter.
No, that they filed an affidavit stating it is incorrect.
Those are not the vital point. Vital point is.
And in the meantime, you have also retired from the service from 2020.
Please pass on those orders which have been passed, and so that
with a memo
with a memo you give it. ଗୋଟେ memo କୁ ଲେଖନ୍ତୁ ଆମେ ଦେଇ ଦିଅନ୍ତୁ।
ଅଛି ଏକ୍ସଟ୍ରା କପି ଅଛି
ଅଛି ଦେଇଦେବି ମୁଁ ଅଛି ଏକ୍ସଟ୍ରା ଦିଟା ସେଟ୍ ଦେଇଛି
ୟାଙ୍କର ନାଇଁ ନାଇଁ ଏଇଟା ତ ହଉଛି ଗୋଟେ କେସ୍ ରେ ଆପଣଙ୍କର ମହେନ୍ଦ୍ର ପ୍ରସାଦ ନାୟକ
ଆଉ ଗୋଟେ ହଉଛି ନଳିନ ଦାସ
ଏଇଟା ମହେନ୍ଦ୍ର ପ୍ରସାଦ ନାୟକର ଆପଣ ଦିଟା କପି ଦେଇ ଦେଇଛନ୍ତି ଏଇଟା
ରହୁଛି
ହଁ ହଁ
ମୁଁ ଦିଟା କପି ଦେଇଛି
ମହେନ୍ଦ୍ର ପ୍ରସାଦ ନାୟକ ଗୋଟେ ଦେନ୍ ନଳିନୀ ଦାସ ଏଇଟା ଟ୍ରାଇବୁନାଲ ଆଲାଉ ହେଇଯାଇଛି
ଟ୍ରିବ୍ୟୁନାଲ ଆଲାଉ ହେଇଥିଲା ଇଏ କେସ୍ ଟା ଉଠି ପାରିନଥିଲା ତା ସାଥିରେ ଏକାଠି ସବୁ ଫାଇଲ
ଆଚ୍ଛା ଆଚ୍ଛା ଓ ଏକାଠି ଫାଇଲ
ସେ ମର୍ଡର ଚ୍ୟାଲେଞ୍ଜ ହେଇଥିଲା
ଗୋଟେ ଡିସମିସ୍ ହେଲା ତ ଏଇଟାରୁ ଜଣା ହବ ଯେ ଆଲାଉ ହେଲା
ମୁଁ କିନ୍ତୁ କନଫର୍ମ ଯେ ମହେନ୍ଦ୍ର ନାୟକ ମତେ ଇନଫର୍ମ କରିଥିଲେ he has got the benefit
ଚେକ୍ ହେଇଯିବ କିଛି ବ୍ୟସ୍ତ ନାହିଁ
ये जो this lady approached the tribunal when
my client or नलिन दास
no no ଆପଣଙ୍କ client ମାନେ ଏଇ ଯୋଉ ଏଇ କେସ୍ ର ରେସ୍ପଣ୍ଡେଣ୍ଟ ଏଇ କେସ୍ ର ରେସ୍ପଣ୍ଡେଣ୍ଟ ଶ୍ରଦ୍ଧାଞ୍ଜଳି ଦାସ କେବେ ଫାଇଲ କଲେ
ଶ୍ରଦ୍ଧାଞ୍ଜଳି ଦାସ ଫାଇଲ 2010 along with others
ହଁ ହଁ ଏଇ ତ 2013 ସବୁ ଗୁଡାକ ଆଲାଉ ହେଇଛି
ସବୁ ଆଲାଉ ହେଇଛି
ଆପଣ ଆଦରୁ ରିଟ୍ ଅପିଲ ଫାଇଲ କରିଛନ୍ତି କି ନାଇଁ ଦେଖନ୍ତୁ
ନାଇଁ ରିଟ୍ ଫାଇଲ କରିଥିବା ଡିସମିସ୍ ହେଇଯାଇଥିବା
sorry
because tribunal has disposed
so he must have filed it right
just check
Mahendra Naik has got the benefit that he was telephoned that he got
check
no
could be they might have filed a writ that may have been dismissed
ଏଇଟା ଆପଣଙ୍କର ନଳିନୀ ଦାସ ବି ଦିଟା ଦେଇ ଦେଇଛନ୍ତି we are keeping one and handing over to another ହଁ ଏଇଟା ମେମ୍ବର ସହିତ ଦିଅନ୍ତୁ ଏଇ ଦିଟା ଆପଣ ଡବଲ ଦିଅନ୍ତୁନି
ସିଙ୍ଗଲ
ସଜାଡିକିନି ଦିଟା ସେଟ୍ ଦେଇ ଦିଅନ୍ତୁ ହେଲା we are just when you give we will give number ଟା ଲେଖି ଦଉଛି ହେଲା
you also find out
I'll find
just ଲେଖନ୍ତୁ this writ appeal has been filed by the state of Orissa challenging the order dated 29/11/2021 passed by the land single judge of this court in WPC OAC number 690 of 2013. Stop. It appears that the said writ petition was filed by the respondent challenging the order dated 5/11/2012 passed by the State Administrative Tribunal wherein her claim for extension of similar benefit like content lady na Kanchanbala Satpathy. Kanchanbala Satpathy was rejected on the ground that he approached the tribunal at a belated stage. The land single judge, after hearing the parties, has been pleased to hold that when similarly situated employee has already been extended benefit merely because the petitioner bracket like respondent in this writ appeal approached the tribunal at a belated stage cannot be a ground not to extend the benefit to the petitioner, as it would be in violation of Article 14 of the Constitution of India. Land counsel for the state, while placing a date chart and also the citation in the case of state of Uttar Pradesh and others, versus Arvind Kumar Srivastava and others, reported in 2015, bracket 1, Supreme Court cases 347, argued that the respondent of this writ appeal was a fence sitter, and after Kanchanbala Satpathy got the relief from the government by order dated 28/8/2009, after her original application was allowed on 16/11/1998, and writ petition filed by the state was dismissed on 23/9/2008, and the SLP preferred by the state was also dismissed on 27/4/2009. The Land Council for the state, during course of argument, submitted that similarly situated person like one upon jota dekhele koda order ta dekhun tar reject kortile or tribunal
Dilip Kumar Naik.
Page
page number 15 of the additional affidavit.
15 of the additional affidavit. 15 ko padhe similarly situated person, namely Dilip Kumar Naik, who approached the State Administrative Tribunal in OA number 259 of 1990, what the original application was dismissed by order dated 20/10/1998. However, the Land and Council for the state is unable to say whether the said applicant, namely Dilip Kumar Naik, preferred any writ petition challenging the aforesaid order dated 28/10/1998 or not, and he seeks some time to obtain instruction in that respect. Mr. Patro, Shadashiv Patra, Land Council, appearing for the respondent, submitted that file se memo annexing some orders passed in the case of similarly situated person like Mohendra Prasad Naik in OA number 136 of 2013, disposed of on 16/11. C OA number 136 bracket C of 2013, disposed of on 16/11/2016. So also Nalini Das in OA number 138 bracket C of 2013, disposed of on 27/4/2017. Stop. The memo with the orders are taken on record. Copies of the orders have also been handed over to the Land and Council for the state in court, who seeks some time to verify as to whether the state of Orissa challenged the aforesaid orders passed in case of Mahendra Prasad Naik, so also Nalini Das, before this court in any writ petition or not. Achha. The Land Council for the state shall also obtain instruction whether any similarly the cases of any similarly situated persons is sub judice disposed of by this court or not. So put up this matter on
or they have been granted
and or they have been granted
granted to Kanchanbala Satpathy.
Kanchanbala Satpathy. So you want to so 2 weeks means today is 3rd. So whether it will come on 17th,
24.
Place this matter in the week commencing from 24th
May-
March
May I
2025.
prefer a copy of the order?
Free copy of the order be handed over to the land council. Yeah.
Okay. Important.
I can vote.
Please, Your Lordship,
Yeah.
So, that the petitioner, the Department of Railway has been accepted the order of the Millet Tribunal, where the Millet Tribunal was reached to allow the original application on the wrong interpretation of the provision of rules, which has been in Your Lordship.
Just you come to the prayer portion of the in the original application, which is there in page number 19 or internal page is 4.
Yes,
Is relief
madam.
which was sought for.
Yes, madam. May I
Yeah.
read it, madam? Has been filed this original application following prayers. One, to quash the memorandum dated 15/11/2019 under Annexure A by 4, and to direct the respondent number 2 to reconduct the written examination and viable for formation of Group B panel of AEP through LDC against 30% quota as per the notification dated 12/3/2019, and to direct the respondent number 2 allow the applicant to participate in the written test, and in case of succeeding the viable test, and or direct the respondent number 2 promote the applicant to the post of AE Group B at par with the candidate promoted by the memorandum dated 28/11/2019 with a constitutional financial benefit, and to pass the order of injection dated 30/7/2020 under Annexure A by 6 and pass any other.
Now you come to the operative portion where the relief was granted. That is
at page 7, at para 7.
Paragraph 7.
Yes, ma'am. The further contention of the respondent that there is no provision for the supplementary written examination for absent candidate also falls flat in view of the Chapter 2 section rules governing promotion of the subordinated staffs, which deals with the procedure relating to conduct of examination. Rule 207.1 of the rules clearly prescribed that one more
not more
not more than one supplementary selection should be held to cater to the absentee. While holding the supplementary selection, all care and caution should be exercised to ensure that the employee who did not avail of the main selection has provided the opportunity at the supplementary selection measure to be notify the employees either for the main selection or the supplementary selection, particularly in cases where the employees are serving outside the railway, including the employees on deputation, should not be routine. Hence, going through the notification as well as the rule provision referred to above, this tribunal has no hesitation to hold that applicant has unjustly been kept out of the selection process. Accordingly, we direct the respondent to conduct the supplementary written examination for the applicant as per the notification dated 25/3/2019 and to take further follow-up action as per the rules. It is made clear that the event applicant comes out successful in the selection process, he shall be promoted to the post of AE Group B at par with the candidate promoted by memorandum dated 28/11/2019 with all constitutional benefits. The which extent stated above, party to be their own postman.
Yes.
So what is wrong with the order?
I respect that this provision which has been relied upon by the tribunal.
Yes.
You'll also make prior to that, I have to just point out here the advertisement made pursuant to which she is applied. You kindly see, my lord, that is at page 53, running page 53. It is a part of my counter. That's Annexure 4. Annexure 4, page 53. That it is part of that writ appeal. This is the advertisement pursuant to which is applied. Your lordship may kindly see.
Annexure 4 starts at 125, so it must be internal or what?
Annexure 4 that has been attached to that writ appeal. Running page 52. It is that.
64 the coaching per. Item number 2.
This is the advertisement for which the applicant applied, madam. That is, madam, it is promotion for impanelment the list for group B to group C. You'll also make the next subsequently at 53 page. You'll also at the bottom. As per the rules, you'll also make before the last paragraph that has been underlined. As per the rules, no supplementary examination is permissible in LDCE for the absentee under any circumstances. That has been specifically stipulated in the advertisement. But what I bring to notice of this honorable court, that the rules which has been interpreted by the non tribunal is in respect of the regular promoting. That is to promotion so far as to selection to group B and group C. Those who are in the regular cadre, then the vacancy has to fill up 70% and rest 30% from the that departmental competitive examination, which has been as the petitioner has been applied. On that year, it's come to.
No, that is the reason why they challenge that notification itself, because it is contrary to your. That was the ground also. Just come to that paragraph number 6 of that impugned judgment or order dated 3/7/24, page number 22. This notification which you are referring to, come to paragraph number 6.
6.
जो order ta पढ़ुथिले आपण paragraph 7 को आपण पढ़ुथिले. Please come to paragraph 6, previous paragraph.
We have had learned counsel for both the parties. I have gone through the material placed on record. Although the respondent have submitted that in the notification dated 25/3/19, it is a clear mention that detail would be uploaded on Southeastern Railway's website. That is www.ser.indianrailway.gov.in. After going through the said notification, we do not find that any such specification or stipulation was made therein. To the contrary, it has been specifically mentioned in the notification that the concerned staff officer of the Unity Division who deals with the staff's establishment matter should be circular this letter to all concerned, including those on leave, training, and deputation. That may also ensure that the notification and all subsequent notification of this selection are circulated in all Unity located in their territorial jurisdiction. It was only noted in the notification that this is also being uploaded. That is the website of www.Southeastern Railway Indian Railways.gov.in. Hence, in our considered view, the respondent have failed to comply with the conditions stipulated in the notification, so far as they are not intimated the applicant about the conducting written test.
All right. Now you about this that you in that notification you have specifically stated that there would be no supplementary selection. But the learned tribunal has quoted, because they have challenged that notification itself. Stated that in the chapter 2 section rules governing promotion of the subordinate staff, which deals with the procedure relating to the conducting examinations, a rule has been quoted where it stated that one supplementary selection is permissible.
But what in respect to the error on part of the record, you also make
okay, Mr. Marana, two things. One is there any error in the order of the tribunal that you have not complied with your own procedure of intimating all the departments about this.
That you'll also may kindly see.
No, you tell us yes or no.
Yes, but that thing, madam, all this.
Because if all the employees are not intimated, not aware, they are deprived of appearing.
In all cases, no personal intimation has been sent to anybody.
Personal. The sections, departments that we have not
Yeah, suppose somebody would be in deputation.
As per the notification of that circular which is issued, that would be published in the website.
Additional. Additional. That is not the only thing. That is additional. Will also be published.
You'll also be kindly see the provision which has been quoted by the tribunal. It is in respect of the vacancies and the regular vacancy. You'll also be kindly that is I would point out. At Annexure 5 at page 54 in the section.
Regard supplementary.
Yes, madam.
We are saying about intimation.
Intimation, what is our stand? Because we are
not stand. What is your procedure which is normally adopted?
We that has uploaded in the site.
No,
that has been given that no personal communication has
not
been
personal to the departments and where they are posted because
अपना deputation अन्य गोटे department को नहीं जाइछंती समस्ते आपण ये कले जे क्लास 2 रु ए ये को जमा आपण को प्रमोशन होबो क्लास 2 रे जो माने अछंती लेट अस से फॉर एग्जांपल से माने सपोज डेपुटेशन अन्य कोनसी डिपार्टमेंट रे काम करछंती are you not supposed to intimate them because normal process re they might not be aware that public website re kole so that is why
tribunal has referred to this
referred to
that is the main ground subsequently appearing supplementary is subsequent a supplementary na hole whole thing has to be set aside
because that what has should have been those are made the party. And this is the seat to confine to 5%. The tribunal should have been directed that those last person should be go out.
Now, what should be done first satisfy whether the order of the tribunal is wrong.
But so far
that you are saying is correct. Communication has not been done, so that they have been deprived. That you are agreeing that the order is correct.
That in respect that the communication has been not been made, only that has been uploaded on the website.
Yes.
That is happened. But that individual communication has been not made.
Tribunal has not said about individual.
Because we have made a specific stand also in that in the respect of counter affidavit file before the tribunal.
Not important. You refer to your regulations.
So far as that departmental communication has been not been, you also may put up.
You would have say your website
notification. Either thiva upon counter re ki not thiva. Au extra kon nebe.
That departmental communication has been.
No, that is.
In that it is mentioned also in that notification itself. It states that the concerned staff officers of the units or division who deal with the staff establishment matters should circulate this letter to all concerned, including those who are on leave, training, and deputation. So they may also ensure that the notification and all subsequent notification of this selection are circulated in all the units located in the territorial jurisdiction.
In fact, the meaning of this is personal intimation.
That is as if it. But you have only uploaded in the website. That's all.
That. So, but
how do you justify?
So your submission is not correct. That this means that personal intimation. Circulation means to those staff means them. They have to be known. Intimated.
That I will specifically understand that. You also may Monday. Monday you also may put them on.
ସେଟା ଗୋଟେ ଆଉ ଗୋଟେ ବର୍ଷନ୍ତୁ ଅନ୍ୟମାନେ ଯଦି ଥିବେ ସମସ୍ତଙ୍କ ପାଇଁ କରନ୍ତୁ ଗୋଟେ supplementary save whether he has made parties or not that is a different matter but they have been deprived.
He made party those who are selected
that
and their appointment.
That will
but
see.
That their appointment also challenges in that notification that Annexure 4 it is respect of their challenge. But the tribunal has not been whispered regarding.
That is a technical ground that we'll see.
Because that seat is confined to for the 5 seats.
Yes.
Once he be selected, somebody has to go. That has not been silent about the tribunal in that.
Instruction where the others are also there.
Now,
others have been deprived.
This petition has been filed by the Union of India and others challenging the order dated 3/7/2024 passed by the London Central Administrative Tribunal, Cuttack Bench Cuttack, in way number 260 oblique 00138 of 2020. In allowing the original application filed by the opposite party, Gopal Chandra Naik, and directing the respondents in the original application bracket like the petitioners in this writ petition to conduct supplementary written examinations for the applicant as per notification dated 12/25/2019 and to take further follow-up action as per rules. The London Tribunal further observed that in the event the opposite party comes out successful in the selection process, he shall be promoted to the post of AEE bracket Group B at par with candidates promoted by memorandum dated 28/11/2019 with all consequential benefits. In paragraph number 6 of the imbue order, the London Tribunal has held that as per the notification dated 25/3/2019, which was uploaded on ACR's website, www so and so paragraph 6, it specifies that the concerned staff officers, inverted comma, the concerned staff officers of the units of the divisions, comma, who deal with staff establishment matters should circulate this letter to all concerned, including those on leave, public training, public deputation. They may also ensure that the notification and all subsequent notifications of the selection are circulated in all units located in their territorial jurisdiction. Mr. Maharana London Council, it is Central Government Council appearing for the petitioners submitted that he has instruction. We are writing in this way. He has instruction that except uploading the notification in the website, ACR's website, the notification was not communicated to all concerned, including those who are on leave, public training, public deputation. That is your instruction. However, he seeks some further time to obtain some further instructions in the matter. Put up this matter. You want it next Monday on 10th of March 2025.
The senior panel council.
Senior panel council.
That certified copy has not been filed at the time of filing.
Which certified copy?
You filed one to dispense with.
I already filing today.
You are filing today. IN number, IN number 1086 of 25. This is an application filed for dispensing with the filing of the certified copy. However, the Mr. Biswajit Maharana, so and so, files the certified copy with a memo which is taken on record. In view of such filing of this certified copy, the interim application is disposed of. Eta upar likh debe, tapre eta upar. Yes.
Item 3.
Also, criminal matter has been assembled. My learned senior is already appearing from the opposite party. I am serving the copy also taken up. Then
since the opposite party has already entered appearance to advocate so and so, let a copy of the writ petition.
Already saw.
Ajay, and the copy of the writ, and it is stated by the Mr. Biswajit Maharana and so that the copy of the writ petition has already been served and the land and council for the opposite party, the single the opposite party.
Opposite parties.
Parties. Mother and son. ठीक है, opposite party. On the request of the land council, so Mr. Maharana, this matter will be listed on 17th. 17th. All right. On 17th March 2025.
Item 4.
Item 4 matter that is matter pertaining to fixation of seniority matter. That similar matter has been disposed of. That has been referred in the judgment of the learned tribunal, which has been dismissed by the Honorable Court. That has been assembled before the Honorable Appeals Court. And the matter is sub judice there, and the Honorable Court hears the matter.
Where is there those orders?
That assuming
first come to the order of the learning tribunal.
Yes, madam. This matter has not been stated.
No. You said that referring to the
yes, madam.
So which is that matter? Which paragraph it has been referred to?
That at last paragraph, at page 26, paragraph.
Page 26.
Yes, madam.
In view of the detailed discussions made in OA number 528 of 2017.
Yes, madam.
Please place that paragraph in entirety. Then you.
In view of the detailed discussion made in OA number 528 of 2017, the seniority list published on 1/11/2013 is hereby passed in respect of the applicant with the direction to publish revised seniority list showing the name of the applicant at the appropriate place, taken in to considering his date of induction to the Group B service on 27/2004, and consider the case of the applicant for the Group A, taking into consideration his date of promotion to the Group B service on 27/2004. As per the revised seniority list to the issue as directed above. The above direction is also being carried out basing of the final outcome WPC number 25623 of 2020 pending on for the Honorable High Court.
This 25633 of 2020 challenge the order passed in OA number 528 of 2017.
No, it is a separate way. It is the batch of case matter.
Okay.
In respect of the seniority has been fixed. Okay. They have assembled all this order also composite order.
Okay.
In the 3 ways order has been challenged. That one composite order has been passed.
Now this OA number 528 of 2017 challenging that order, which writ petition was filed before this court?
This writ petition has filed two. That is one Sushant Kumar that I have to assume that.
No, you made a submission that the very order which has been referred to by the London Central Administrative Tribunal was challenged before this court in a writ petition by the central government or the Union of India, and that was dismissed, against which the SLP has been preferred, and SLP in which stay order has been passed off.
Yes, ma'am.
So please
that 2566, that is that way that I have to settle. But what I beg to state, madam, the batch of case has been filed before the tribunal, out of which the earlier batch which has been rejected, that has been assembled in 25633 of 2020, where the tribunal has noted that this is also follow the order passed by this court.
I know what is the order passed in this WPC number so and so.
That has been dismissed.
So where is that? Have you got a copy of that order? And also the order of the Honorable Supreme Court.
Supreme Court order is there, my lord. That Your Lordship may kindness.
Unless we know that what is the result of WPC number so and so.
Your Lordship, I will detail giving. Your Lordship may put up tomorrow, my lord. I will give you all this.
No, we are keeping it day after tomorrow. We give it that about that order, final order which has been passed in the writ petition. So also the order passed by the Honorable Supreme.
Yes,
right. Look at you. This writ petition has been filed by the Union of India and others challenging the order dated 14/12/2023 passed in way number 570 of 2017. Which was filed by the opposite party. It is এটা করছি অন্তু এটা হচ্ছে ওয়ে নাম্বার
570 of 2017
ওয়ে নাম্বারটা লিখলেন না 570 আচ্ছা which was filed by the opposite party Lingaraj Nodal. And the same was disposed of analogously with the original application filed by one Madan Mohan Patnaik in way number 260/00528 of 2017. In the operative part of the order dated 14/12/2023, the Lenin Tribunal has seems to have allowed the original application, taking into account the order passed in way number 5/8 of 2017. However, it is observed that the direction that has been mentioned in the concluding paragraph shall be carried out based on the final outcome of WPC number 25633 of 2020, which is sub judice before this court. Mr. Maharana Lenin, Senior Panel Counsel, submits that the said WPC number 25633 of 2020, which was filed by the Union of India, was dismissed by this court. However, the Union of India has approached the Honorable Supreme Court and the SLP is sub judice, and there has been an order of stay of operation of order passed by the Lenin Central Administrative Tribunal, and the matter may be taken up day after tomorrow, so that he will file the order passed in WPC number 25633 of 2020. So also the order passed by the Lenin Honorable Supreme Court in the SLP. It is this matter on 5th of March 2025.
And it may be taken up on 6th.
अच्छा all right, ठीक है 6th of March 2025.
Item 5.
Item 5 may please. In this case, the petitioner has approached this honorable court, whereby his application under section 18 was already disposed of by the learned referral court, and since 2019 until date, the opposite parties have not disbursed the amount. Lord, in similar matters, this honorable court has already.
The 6th of 9, 2019, the order was passed.
My lord, 6/9/2019.
And it went in your favor, of course.
My lord.
So there was the direction to award the compensation. Thereafter, what steps you have taken? Also?
Thereafter, my lord, they have not yet dispersed and the entire.
Representation.
No, my lord.
And that order has attended finality.
My lord, sir.
So we take take instruction.
Similar matters have already been disposed of. This honorable court has directed the opposite parties to disburse the amount within a stipulated period.
Order will be more effective after if they get instruction.
Once they get the instruction, that you can get a more effective order. So let them take instruction. They may disburse it if they have not challenged. Mr. Nayak, get the
Well, you are giving us a similar order. We have the similar orders to take instructions also.
So we are keeping it on 17th. We are getting $24. This petition has been filed by Trilochian Rana with a prayer for a direction to the opposite party to sanction and disburse the compensation amount in favor of the petitioner pursuant to the order dated judgment and order dated for the 6/9/2019 passed by the Land and Civil Justice Senior Division Bhavani Patna in LAR number 36 of 2019. It is the contention of the Land Council for the petitioner that even though more than 5 years, more than 5.5 years, more than 5 years have passed in the meantime since the date of pronouncement of the judgment, but the petitioner has not yet been disbursed with the compensation amount as has been directed. The Land Council for the state 6 week time to obtain instruction as to whether there is any challenge to the aforesaid order, judgment dated 6 September 2019 or not, and if not, why the compensation amount has not yet been disbursed in favor of the petitioner Trilochian Rana. List this matter in the week commencing from 24th March 2025. Free copy of the order be handed over. Yes.
That's item 6, 8, 9, and 12 also same.
6 is not the same.
The legal representative.
Yes.
6 and 9 both legal representatives. 8 and 12 same.
Just a minute.
LAR case will also be different. So please tell us.
Same joda kuchandi kuda.
5, 8, and 12.
Petitioner favor rahi order ta hai thi.
हाँ मैंने 5, 8, 12.
5 to gala. 8 and 12.
8 out. We are asking so that the orders will be similar. 8 will not be similar because you are one of the petitioners. There are 9 others.
Then let's go to item number 6. Item number 6 ta khali koi
Item number 6 is the legal.
So the order was passed in favor of
the father of the petitioner,
Hasi Rana, and here who is the petitioner?
Ratho Rana, son of.
How is?
Have you stated that there are no legal other legal heirs? You are the only legal heir.
The father of the.
Correct.
That there is nobody else.
No action in the meantime.
Regarding enhancement.
My lord, here the procedure is after sanction of the amount, the RI will conduct an inquiry regarding legal error and the petition and all these things.
They pass the order that they need to discuss in favor of the petitioner. they will say that I could have directed, but physical maybe they have other legal entities.
That's of
So that is why in case of such an issue where the
yes, your chief has passed an order. Good order ଦଉଛି ନାଇଁ ଗୋଟେ ଅର୍ଡର ଆପଣ ସେଇଟା 28 ରେ ଏଇଟା 18 ରେ ଆପଣ ପଢିଥିଲେ ଆଜ୍ଞା next page. Disbursement of the compensation amount in for the petitioners in LAR number so and so and or their legal heirs as the case may be. Last 3 lines. In similar case, you also direct. Yes. Say same case, say death ହେଇଥିଲା. Ultimately, the RI will conduct an inquiry and enjoy. Dispose of କରିବେ honestly they are
My lords.
Fine. I'll find.
I got the instruction government is paying 150 crores towards interest in all these land acquisition cases. No. Here what happened? As because they are not paying, government is paying 15% interest as per the statute to the people. সবাই পড়াশোনা করবে চলো বস কিছু while I was in government, I was sitting in a meeting, and that was the statistics they were given. And when they blame on the court regarding pending of the case, I blame on the government. You are not taking any steps. God, your ship can dispose of.
Okay, let you bring that instruction to dispose of the next. We all will
Father.
Layer case number 39.
Next.
Item 8.
If you not fully on that very day, Mr. Nayak, you batch number 25 item number 25 sorry for this 24 24
8 है 12
Layer case number 40 of 2009.
40. Item 8. Item 8. Item 9. Item 9 is the legal error. Same as item 6. ବାପା ନାଁ ହଉଛି ଦାନର ରଣ
ଦନାର ମୁଁ କରେକ୍ସନ ସବୁ କରିଦେଇଛି
stupid.
So this could be you are keeping it on 24 from that day. Yes.
Also, it is not fair and pending so long. If we say what is correct, like thing is that is the good for the petitioner.
I'll add it.
After item 12, ma'am. For Molotov, LR 33 of 2019. Same, the petitioner is here.
That is also that I don't know why the London Council for the petition and the social argument submitted that even though in pursuance of the here the instruction that even though pursuance of the judgment pronounced by the civil judge seniority in similar cases
Under section 18.
Under section 18 of the Land Acquisition Act 1890
Yes.
for the announcement of compensation, the orders have been passed since 2019 and amount has not been deposited. The amount has not been deposited for which the state is required to pay huge amount towards the interest. The Grand Council for the state also obtained instructions from this house. This is valuable.
Item number 7.
May I please let madam? Madam, the petitioner residing near the Mahingula temple, madam, and performing seva karya for last 50 years, madam. Now the area has been acquired by the Mahingula OCB, madam. And yes, sir. Yes, sir. Lordship, we are ready to evict, my lord, but rehabilitation.
No, but you are staying there. What is the material? There's nothing other than your government.
My lord, can't you see annexure 1?
Annexure
Notice
1.
given to eviction notice, my lord.
Okay. Annexure, this is item 7.
Yes, lord.
Annexure 1, read out annexure 1.
My lord,
महाशय ना कौन अच्छी ऊपर
पाकिली गुच्छा my lord माननीय श्रीयुक्त प्रकल्प अधिकारी महोदय हिंगुला उसी my lord.
कोटा पढ़ुଛନ୍ତି ଆପଣ annexure
1 my lord, page 9.
annexure 1 is their letter or your letter?
My letter, my lord.
और ସେଇଟାରୁ କଣ ଜାଣିବା ଆପଣ ରହୁଛନ୍ତି ବୋଲେ?
2 my lord they have given.
Yes.
Annexure 2 my lord.
Yes. ମହାଶୟ ଏହି ପତ୍ର ମାଧ୍ୟମରେ
ଆପଣଙ୍କୁ ଅବଗତ କରାଯାଉଛି ଆପଣଙ୍କ ଘର ଯେଉଁ ଜମିରେ ଗଠନ ହୋଇଛି ତାହା ଖାତା ନମ୍ବର 313 ପ୍ଲଟ ନମ୍ବର 1966 କିଶମ ଘରବାଡି ଏକ ସରକାରୀ ଜାଗା।
ହୋଇସାରିଛି ଠିକ ଅଛି।
What do you want?
As the rehabilitated, then we are ready to evict my lord.
ଏবার କଣ 24,000 ମିଳି ସାରିଲାଣି ଆପଣଙ୍କୁ?
24,528 ଅନୁମୋଦନ ହେଇଛି।
2008 ରେ ପୁଣି
ଏ ରାଶିକୁ ପ୍ରାପ୍ତି କରି ବାସଗୃହ ଭାଙ୍ଗି ଓ ସ୍ଥାନକୁ କରି ହସ୍ତାନ୍ତର କରନ୍ତୁ। ଆଚ୍ଛା ପ୍ରାପ୍ତ କରି ମାନେ ଆପଣ ନେଇନାହାନ୍ତି?
No my lord. They have not given and
ପଇସା ଥୁଆ ହେଇଛି ଆପଣ ନ ନେଲେ କଣ କରାଯିବ?
They have not dispersed my lord. Annexure 3 my lord I have given.
Disperse ମାନେ ଆପଣ ମାଗିଲେ ସେ ଦେଲେନି ତାଙ୍କୁ ସେ କଣ ଭଲ ଲାଗୁଛି ଇଣ୍ଟରେଷ୍ଟ ଦବା ପାଇଁ ଆପଣ ନେଇ ନଥିବେ କାହିଁକିନା ୟୁ ଆର କଣ୍ଟିନ୍ୟୁଇଂ ଟୁ ଷ୍ଟେ ଦେयर। ମୋ ସ୍ଥାନକୁ ହିଙ୍ଗୁଲା ଅଫିସ ଏତିକି ଆପଣ ଦ୍ଵାରା ଜମି ହରା ଗ୍ରାମବାସୀଙ୍କୁ ଦିଆଯାଇ କୌଣସି ଯୋଜନାରେ ହିତା ନୁହନ୍ତି। ଆପଣ ଏମସିଏଲ ଦ୍ଵାରା ଜମି ହରା ଗ୍ରାମବାସୀଙ୍କୁ ଦିଆଯାଉଥିବା ଅନ୍ୟ କୌଣସି ଯୋଜନାରେ ହିତାଧିକାରୀ ନୁହନ୍ତି। ମନ୍ଦିରର ବିକାଶ କାର୍ଯ୍ୟକଳାପ ପାଇଁ ଏହି ଜମି ଜରୁରୀ ଅଟେ। ଆଚ୍ଛା ସେ ଯୋଉ ମନ୍ଦିର ଇଏ ଗୁଡା କରିବା ପାଇଁ ଚାହୁଁଛନ୍ତି ସେଇଟା
ଏଇଟା ଏଇ ଯୋଉ ଆପଣ ଲାଷ୍ଟ ଯୋଉ ରିପ୍ରେଜେଣ୍ଟେସନ ଟା ଦେଇଛନ୍ତି ବା ଗ୍ରିଭାନ୍ସ ପିଟିସନ ଯା କହୁଛନ୍ତି that is in 12/2024.
Yes lord.
It is submitted on 31/12/2024 or what? ଉପରେ ଯୋଉଟା ଲେଖା ହେଇଛି
ସିଏ ଦେଲା ପରେ ଦେଲେ ନା ସେ ଆପଣ ଦେଲା ପରେ ସେ ଆପଣଙ୍କୁ ଏଇଟା ଦେଇଛନ୍ତି? Because annexure 2 is 31/12, 3 also 31/12.
ପାଇଲା ପରେ ବୋଧେ
ଦେଇଛନ୍ତି ବୋଲି
ଏଇଟା ଉପରେ ଗୋଟେ ତାଙ୍କର ଇଏ ସିଲ୍ ଟା
ଦେଇଛନ୍ତି ରିସିଭ କରିଛନ୍ତି
31
ହଁ ରିସିଭ କରିଛନ୍ତି ସେଟା
ମୁଁ ପାଇ କଣ ମୁଁ
ପାକିଲି ଗୁଚ୍ଛା ହଜବେଣ୍ଡ ନେମ୍ ଆଣ୍ଡ
ସମସ୍ତ ଦିଆଯାଇଛି ବୋଲି ଉଲ୍ଲେଖ
ଦେବା ପାଇଁ ଜଣାଇଥିଲେ କିନ୍ତୁ ଆପଣ
ଚିଠିକୁ ରେଫର ହେଇଛି। ଆଚ୍ଛା ହଉ
ଏଠି ସୁଯୋଗ କରିବାକୁ
ନାଇଁ ଗୋଟେ 26 ତାରିଖ ଚିଠି ତ ଦେଇନାହାନ୍ତି ଆପଣ ଯୋଉ ଚିଠିକୁ ରେଫର କରିଛନ୍ତି in your 31st letter that ଚିଠି you have not given.
They are uneducated people. They are not papers.
ଏଇଟା ହଉଛି ଆଉ ଗୋଟେ ଚିଠି
28/12/24 ର ଲେଟରଟା ଆନେକ୍ସ କରିଛି ଯୋଉଟା ଆନେକ୍ସ ତା
ଦେହରେ ଡିଟେଲ ସବୁ ଅଛି। କଣ କରିବ ଯୋଉ ଇଏଟା ମନ୍ଦିର ଡେଭଲପମେଣ୍ଟ ପାଇଁ ମନ୍ଦିର ଡେଭଲପମେଣ୍ଟ କଣ ହେଲାଣି? ବାହାରିବନି ଆଉ କଣ ଏଇଠି ହେଲା ତେଣୁ କେଉଁଠି ନିଯୁକ୍ତି ଏବଂ କେଉଁ ଜାଗାରେ ପ୍ଲଟ ଦିଆଯାଇଛି ଆମଠୁ 7 ଦିନ ମଧ୍ୟରେ ଚିହ୍ନଟ କରାଦେଇ ଗଲେ ମୁଁ ସେଇ ଜାଗାରେ 6 ମାସ ମଧ୍ୟରେ ଘର ତିଆରି କରିବି ଏବଂ
କଣ୍ଡିସନ ଆପଣ କେମିତି ରଖିଛନ୍ତି? ଏଟା କୋଉଠି
କେମିତି ଆମେ ଏଇଟା ଡିସ୍ପୋଜ
କୋଉଠି ଦେଇଛନ୍ତି କଣ ଦେଇଛନ୍ତି ଆମକୁ ଜାଗା ଦିଅନ୍ତୁ ତାପରେ ଆମେ ଯିବୁ ଏ ରିପ୍ରେଜେଣ୍ଟେସନ ପଇସା ଦେଇନାହାନ୍ତି ଅଲ୍ ରାଇଟ୍ ବଟ୍ ସେମିତି କିଛି terms and conditions ନଥିଲା ଯେ ଏଇ ଜାଗାରେ
MCL's letter, my lord, says that after ଆପଣ MCL ଦ୍ୱାରା ଜମି ହରା ଗ୍ରାମବାସୀଙ୍କୁ ଦିଆଯାଉଥିବା ଅନ୍ୟ କୌଣସି ଯୋଜନାର ହିତାଧିକାରୀ ନୁହଁ।
ମିଳିବନି so ସେଇ ଯୋଉ
Because the land is a government land,
right
that's why.
saying କିଛି କୋଉଠି ଦେଇଛନ୍ତି ସେ କଥା ମତେ ମିଳିବନି। No, Miss Biswal, is it stated in letter 26/12/2024 that you have been granted land in lieu of that?
No, madam.
ତାହେଲେ ଆପଣ ସେ ଚିଠିଟା ରିପ୍ଲାଏ କଣ ଦେଲେ ତାହେଲେ? ଆପଣ କହୁଛନ୍ତି କୋଉଠି ଆମକୁ ଜାଗା ଦେଲେ କଣ ଦେଲେ, you are referring to that letter but you have not given that letter.
You have not given matter. The similar matter in 10, 11 and 14 millions.
Similar matter share je ଆଉ
express no opinion on the merits considered. This writ petition has been filed by petitioner Pakili Gochai with a prayer to pass the notice under annexure 2.
In item 10, that letter has been annexed in page number 9.
Page number 9?
In item 10, my lord, page number 9, that 26/12/24 letter has been annexed.
Wonderful. ଓ ତାମାନେ ଇଏ ଗୋଟେ ଫ୍ୟାମିଲି ସମସ୍ତେ ମାଗୁଛନ୍ତି, ସମସ୍ତଙ୍କୁ ଗୋଟେ ଗୋଟେ ପ୍ଲଟ ମିଳିବ।
They are residing in the same premises, madam.
ସମସ୍ତେ ଗୋଟେ ଗୋଟେ ପ୍ଲଟ ମାଗିଦେବେ।
Annexure 2 dated 31/12/2024.
So ଧର୍ମା ଗୋଚ୍ଛାୟତର ସ୍ତ୍ରୀ ଆଉ ସବୁ ପିଲାମାନେ ଗୋଟେ ଗୋଟେ ଜାଗା ମାଗୁଛନ୍ତି, ସେ ତ
Notice given separately, my lord, each one.
As illegal, arbitrary, and contrary to the mandate provision of R&R policy, and for
similar matter listed in court number 6, my lord. In that case, they have given stay and
for
to take
disbursement of the
instruction.
compensation amount and rehabilitation assistance under
single
R&R
bench
policy
order. Yes, you want to give the order letter
of the government with a further direction to the opposite party number 5 to consider the representation of the
ଜଲ୍ଦି ଟିକେ
petition
ଦିଅନ୍ତୁ, ଅର୍ଡର ଡକା ହଉଛି, ଜଲ୍ଦି ଦିଅନ୍ତୁ,
under
ପରେ ବି
annexure
କରିପାରିବେ।
3 within stipulated time.
ସିମିଲାର ମ୍ୟାଟରରେ ଷ୍ଟେ ହେଇଯାଇଛି। ଏଠି କାଇଁ ଆସିଲା, ଏଠି କାଇଁ ଲିଷ୍ଟ ହେଲା, ଏଟା ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ ମ୍ୟାଟର। ଆରେ you are the petitioner there?
Yes, sir. Yes, Lord. Yes, Lord.
During course of argument, the land counsel for the petitioner produced the copy of the order dated 14/2/2025 of the land signatures in WPC number 3550/2025. And 325/2025. The case of Vishwanath alias PC Gujarat and Nepal Gujarat respectively. Where the registry is verify whether the matter should be distributed by the Indian bench of the single. Yes.
14, I believe, 7, 10, and 14.
7, 10, 11, and 14. Seven, 10, 11, 14. 7, 10, 11, and 14.
Item 13.
Here the grievance of the petitioner is that despite a representation being made with regard to enhancement of the amount with regard to the land that has been acquired, the same is not considered. Your Lordship will kindly turn to Annexure 1. I'll just clarify. There is a confusion. So far as this 2013 Act is concerned, Your Lordship will see Annexure 1 series at page 12. The government permitted acquisition by the authorities through private negotiation. Your Lordship may kindly turn to page 12. This is that construction of Ring Road, Barampur, direct purchase of land. This is letter 6/6/2018 in supersession of this department letter number one. So I am directed to say that your proposal is hereby approved for direct purchase of private land measuring so in villages so. Ankushpuri is so far as the Mauja of the petitioner is concerned. As for the following conditions, your Lordship will kindly see clause number 4. The average sale price of the sum of the case land as well as similar type of land situated in the nearest village or nearest vicinity area obtained from proper revenue authority and duly authenticated by next higher concerned revenue authority should be kept as a record for all future verification. Now, your Lordship, pursuant to this, they issued a notice to me at page 13. And they refer to that 6/6/2018, that is the page 12 document in this notice. Now, pursuant to that, a sale deed is executed by me in favor of the authorities at page 14, and your Lordship will kindly see page 15. This is on behalf of the government by the authority who was authorized. Now, your Lordship may kindly turn to page. That is the difficulty. Page 19, your Lordship may kindly see. Now, this consideration amount they have paid by fixing a benchmark valuation at 25 lakhs 30,000. Yes, I have no. That is why I am represented. Why your Lordship will kindly come to page 18. The collector is the authority. Your Lordship sees ଏଥିର ପୁରା ବିକ୍ରୟ ଧନ so and so ଟଙ୍କା ତୁମ୍ଭଠାରୁ ବୋଲନ୍ତେ ଓଡ଼ିଶା ରାଜ୍ୟ so and so Kajala Nivanuti Anupura Satpati approved in so-and-so meeting under the chairmanship of collector and district magistrate. Now they did it at 25 lakhs 30,000. Now your lordship may kindly turn to page 23. In the year 2020-21, the benchmark valuation was 1 crore 54 lakhs. So that is why the collector being the authority, I have only represented to the collector saying I have been paid less. It may be considered. Similar kind of, but your lordship will see this statute also 2013 Malad Act, which your lordship was pleased to refer to, deals with such contingencies also, your lordship, but that is in respect of private companies. Here only the government authorities have purchased. Your lordship may kindly see clause 3 of section 2. So since this is in respect of private company of this Malad Rehabilitation Act, RR Act 2013. To apply these provisions are applicable and enhancement other things can be. Section 2, your lordship, subsection 3. The provisions relating to rehabilitation, resettlement under this act shall apply in cases where a private company purchases land equal to or more than such limits in rural areas or urban areas as the case may be prescribed by the appropriate government through private negotiations with other owner of the land in accordance with the provisions of section 47. Here, under Annex 1, your lordship has seen the government has approved through purchase through private negotiations. Now, the government has stipulated a condition that you should do it as per benchmark valuation. And admittedly, I am demonstrating from record they have not done it. I have represented to the collector requesting that this grievance of mine may be considered. Now, in fact, if your lordship kindly permit me, I beg to just bring to your lordship notice in a similar, but I am not saying that this will be a precedent. This honorable court. No, I will not say that. I am only saying, but what I humbly beg to submit, I am not that at all. This is this purchase stipulating the valuation is contrary to Annex 1, and the collector being the authority who has approved, I have represented to the collector. This is what I beg to humbly point out to your lordship. And I am demonstrating from record that as against 1 crore 54 lakhs, they have stipulated the benchmark valuation at 25 lakhs, which is grossly low. And I have given a calculation to your lordship at page. Yes, your lordship will see. Yes, madam. Your lordship may kindly see page 25 onwards.
The registered salary is the total amount is 42 lakhs and 17,500.
That is for 1 acre, 60 decimals. Your lordship, that is at page. Your lordship may kindly see the extent of land at page 15. 1 acre, 66 decimals. Have कोटिए 54 हेले कोटिए 54 हिसाब रे हेले it will be more that calculation I have given at page. Your lordship may kindly come to page. That calculation I have given, and that is at page 6 of my writ application, paragraph 7, my lord. This is as per the they have given. This is the calculation they have given. The calculation would be at page paragraph 8. It will spill over to next page, page 7. Page 7. So this will be the value if it is calculated at 1 crore 54 lakhs. Yes, my lord. And the benchmark valuation which I have annexed, I beg to draw my lord's kind attention to that at page 23, your lordship, indicates that for 2020-21 it is 1 crore 54 lakhs. I have obtained it from the competent authority, the sub-register. I am only humbly praying that let them consider. They are not doing that, and your lordship sees series of representations. But these must be also available. I have inquired, I have to find out whether these are all reprehensions or not, my lord, they have said they have reprehended. Therefore, I have annexed all the reprehensions, my lord, for your lordship's kind perusal.
The procedure when it is private, that doesn't mean you can exploit them. What should be the proper thing on basis of instructions we will do. It is not that you will enhance saying that High Court has directed.
One order which in this way we pass the order. The representation is to be considered in accordance with law. We have expressed no opinion. All these things were there. The order which was passed by the authority, that's in the High Court has directed
to enhance.
So this is the thing. That is the reason we are disposing of, but this is treated as something different. That
Same thing.
without expressing any opinion in accordance with law.
He cannot do anything because the authorities.
And on consideration, they could have said that we feel that it should be enhanced instead of saying Honorable High Court has directed us to enhance.
No. They are saying get the order of the High Court.
That is the get the order and.
But can it be enhanced? What is the object of buying on private?
That also, the statute deals with. Only because of the fact that it relates to a private company, I am not citing that.
Exactly.
Exactly.
So there is no provision for enhancing.
But here I am only.
In fact, you may correct me if I am wrong. That this is the whole idea, so that it brings an end to litigation. You will have a sale, so that both parties agree to the price.
May I just humbly point out
yes,
one
definitely.
But had it been a private company acquiring, even the domain of 2013 Act remains for enhancement and everything.
Private company, because then the state is not there. Here is the state and you.
Here, the state itself, while acquiring, stipulates a condition that it should be as per benchmark valuation. So I am only saying that should be implemented. I am not saying anything beyond Annexure 1 at page 12. So that is not happening. That much, and I have demonstrated from record that it is not in accordance with the terms and conditions of acquisition. So they permitted a private acquisition subject to conditions.
Are you saying that it has not been done in accordance with Annexure 1?
That is only. That is my grievance, madam. Freedom of clause, court has reached adhere करता more picture that much
time.
The writ petition has been filed by the petitioner Vinod Chandra Ratho with a prayer for a direction to the opposite parties to pay adequate compensation to the petitioner as per the benchmark valuation in view of acquiring the land appertaining to plot number 2717 under Khata number 703/1397 measuring part area so likely. The land counsel for the petitioner has stated in the writ petition in paragraph number 7 that how the valuation has been made by the authority, which is there in the registered sale deed. However, in paragraph number 8, he has mentioned that if the benchmark valuation is taken as per Annexure 1 series, then it would be a higher amount and therefore the petitioner has submitted the representation, a series of representation before the authority as per Annexure 5 series. The Land Council for the petitioner submits that the authority concerned may be asked to dispose of the representation, and if the petitioner is entitled to get more amount as per the benchmark valuation which has been fixed annexure under Annexure 1 series, the same may be disbursed to the petitioner. Wow. This matter we listed before some other bench in which one of us, Honorable Justice.
नाटा देखिए I'm little काले might be a relation or somebody.
May I just point out, sir? Then your lordship can say, your lordship has been pleased to hear. ये डॉक्टर सुधांशु ये जे ଅଛନ୍ତି ଆସିଷ୍ଟାଣ୍ଟ ରେଜିଷ୍ଟ୍ରାର ବିପି ୟୁଟ୍ର ସେ ରିଲେସନ ନୁହନ୍ତି ତାହେଲେ ଇଏ ଲର୍ଡସିପ କାହିଁକି
से जाओ बेटर टू वाइक ये
ମୋର କ୍ରିଭାନ୍ସ ନାହିଁ ଇଏ ଲର୍ଡସିପ ମୁଁ ତାଙ୍କ ନାଁଟା ବି କହିଦଉଛି ଯଦି ଆପଣ
ଦେଖିଲି ପରା ଏଇଠି
ନାଇଁ ତାଙ୍କ ନାଁଟା ହଉଛି ଡକ୍ଟର ଯଦି ତାଙ୍କ ପୁଅଙ୍କ ନାଁଟା ଯଦି ସେ ଆପଣ ରିଲେସନ ନୁହନ୍ତି ତାହେଲେ ଆପଣ ଶୁଣିଛନ୍ତି କଣ ଅଛି
there are lot of relations we don't know about but in paper ରେ ଯଦି କରିବ ସେ ବାହାରିବେ ଆଉ
ନାଁଟା ମୁଁ ଟିପିକି ରଖିଛି
ଆପଣ ଟିପିକି ରଖିଲେ ମିଷ୍ଟର ମିଶ୍ର
I will never request your lordship to come. ନା ମୁଁ କହୁଛି ଆପଣ ନା ଆପଣ ଦେଖିଲେ ଜାଣିପାରିବେ ଯେ ଆପଣ ରିଲେସନ କି ନାହିଁ ଆଜ ଲର୍ଡସିପ
ଓକେ
ନେକ୍ସଟ since your lordship applied mind
ନାଇଁ ଆମର apply mind କଲାବେଳେ ସେଟା ବାହାରିଲା ଭିତରୁ
All right. Next.
Item 15.
ଲାଗୁନି
Next, item number 15.
ଆଜ ଲର୍ଡସିପ ପ୍ଲିଜ
May please, your lordship. Lordship, as per the order dated 19th February of this honorable court, the affidavit is filed on 21st of February with the land details of the affected farmers.
ଏଇଟା ଗୋଟେ କଣ ଡିଟେଲ ଆମେ ମାଗିଥିଲୁ
An affidavit along with a list of the table indicating the names of the farmers and the description details of the land which are being utilized for construction of the river and mining.
Mr. Naik, have you?
I have received that.
So, where is that affidavit? This additional affidavit?
Lordship, yes, ma'am. Additional.
So, what is your prayer in this writ petition?
For compensation.
Yours is not a registered association.
Not a registered association.
But maintainable.
So, how it is maintainable? Individually, if you come, it's all right, but you are coming through, you are naming your association as a farmer association Banki, but it is not a registered association.
Lordship,
maybe that XYZ might not have been any grievance against the opposite parties, and you 2 or 3 might have come with some motive that to get political mileage or whatever it may be in that respect.
Farmers are affected, and as per the judgment, I have a judgment, your lordship, Akhil Bharatiya Shoshit Karmachari. As per the judgment, the unregistered, the petitions by the unregistered association is maintainable.
Please, sure. Okay. Problem also. And what is the relief also? Let us see. So those must be salaried employees. చెప్పాను 1980.
Which paragraph?
Lordship, page 224, seriatim G. May I read your lordship?
Yes.
Have you given a copy to Mr. Naik? Missy ki padi page 224.
224, seriatim G. A technical point is taken in the counter affidavit that the first petitioner is an unregistered association, and that therefore the petitioner to the extent is not petition to the extent is not sustainable. It has to be overruled. Whether the petitioners belong to a recognized union or not, the fact remains that a large body of persons with a common grievance exist, and they have approached this court under Article 32.
Sorry, one moment. The first petitioner means there were a number of petitioners.
First petitioner in this case, Lordship, is the association.
And second?
Second. In this para, the honorable.
Not para. There's a difference. My association must be there. Other petitioners also may be there in the petition case you are referring to.
But in subsequent lines, the honorable court clarifies.
There must be a paragraph showing who are the petitioners. The abolition of slavery has gone on for a long time. Rome abolished slavery, America abolition, Egypt.
That's the same paragraph at line 3 that specifies the same. Whether the petitioners belong to a recognized union or not, the fact remains that a large body of persons with a common grievance exist, and they have approached this court under Article 32.
They are employees or engaged by the railways.
Okay.
That is different. Union, registered union, that is different.
And in this case, all are affected farmers, and everybody has the land. The land is taken over.
Who are you?
I'm the association secretary, president of that.
In the additional affidavit, what have you stated?
Only the land particulars, the lordship, as directed by lordship. It is only replicated from the register of the association. The membership details were already annexed at Annexure 4, but it was not legible, your lordship.
This is regarding a union. You give us about an unregistered association, whether a writ petition is maintainable. Only the small that point.
Lordship may have any other day at time.
Yes, Mr. You also assisted.
କେବେ ରଖିବ କୁହନ୍ତୁ?
Any day.
Any day means
next week.
Next week.
Mr. Misra. No, I'm asking you. These assistants, is it maintainable? Unregistered association of farmers. The legal entity so that the writ application will be maintainable at their instance.
It's I'm sorry, I could
not
following the code.
It is not the
Not a PI, they own. Anyway, he is looking into it if he asks you for help.
My lord, it is maintainable.
Yes.
It is maintainable.
Yes.
It is maintainable. Even though it is not registered, if their activities working for the society, they can enter to get it. My lord says this.
Lordship, that I was pointing out at the last line, the Honorable Court clarifies it must be fairly be stated that the learned Attorney General has taken no objection to a non-recognized association maintaining the writ petition. But in this,
what does that mean?
Lordship, I will.
That means the maintainability is in question. He did not object, so the court disposed of.
Lordship, I will clarify in the next.
in terms of the order dated 19 to 2025, the Land Council for the petitioners filed an additional affidavit indicating the list of affected farmers with their land details, which is stated to have been utilized for the construction of Mahanadi and Rana River embankment at Mouza, Nisitpur, Tahsil, Damopada in the district of Gattar. In paragraph number 2 of the petition, it is stated that the petitioner number 1 is an unregistered association of affected farmers formed under Article 19(1)(c) of the Constitution and is competent to pursue the litigation on behalf of the affected landowners, being the large body of the persons with common grievance. Reliance has been placed in the case of Akhil Bharatiya Shossit Karmachari Sangh (Railway) versus Union of India and others, reported in 1981 (2) SCR 185. Stop. The Land Council for the petitioner has referred to paragraph to refer to page number.
Paragraph 2, page number 4.
Page number no. Judgment of who page?
Page 2 to 4, seriatim G.
Acha, page 2. Page 4. As referred to page number 224, wherein the Honorable Court has been pleased to observe as follows. Court Cordon Sirapurata enter a technical point to read petitions. The Land Council for the petitioners, so also the Land Council for the state, takes some time till next week to apprise this court whether at the instance of petitioner number 1, this writ petition is maintainable or not. Put up this matter we commencing from 10th March 2025.
No, I have taken his phone number. I'll give him all the references. No, I'll assist him. That's
Yes.
Item 16.
May I please, Your Lordship? Your Lordship, I am alleging the non-compliance and the willful violation of the order dated 5/9/2024 of this Honorable Court, Your Lordship. Your Lordship may kindly turn to page 10 of the brief, Your Lordship, which is the operative part of the order, Your Lordship. May I please, Your Lordship?
Just a minute. So you produced the order on what date?
Yes, Your Lordship. On 11/9/2024, I produced the order, Your Lordship.
Where have you stated? Acha. Paragraph number 3.
Yes, Your Lordship. Annexed it as Annexure 2. The covering letter, Your Lordship.
ये देखो
ये टाइम लिमिट क्या इसमें डिस्क्लोजर पर आता है इंस्ट्रक्शन नंबर private party means the officer is not state cannot take it. National highway authority law.
notice you have communicated, you have the postal receipt.
Yes, Your
Yes,
Lordship.
that is Lucky them. This contempt petition has been filed by the petitioner, Ratho for non-compliance of the order dated 5/9/2024, passed in WPC number 4222224 of 2024 by the opposite, by the contemner. While disposing of the writ petition on 5/9/2024, we have in the operative portion, we have held as follows. In view of the letter for compliance, the Land Council for the petitioner submits that as per the aforesaid order, the petitioner submitted the copy of the order before the authority concerned for taking necessary action on 11/9/2024, and she has also annexed the postal receipts and submits that even though the time stipulated in the order dated 5/9/2024 is already over, but the contemner has not taken any action thereto. Issue notice to the contemner and requisites for issuance of notice by speed post with proof of delivery shall be filed within a week out of this matter. Such answers that yes.
Please, George. Item 17.
Mr. Paji, this is your matter. An application for condonation of delay and the Mr. Pari, are you able
Yes,
to hear
yes,
us?
yes. Audible, man.
Yes. So the stamp reporter has pointed out that there is delay of 215 days in filing this CMAPL.
You said, let's me allow this communicating delay.
No, notice has not been issued. How can we?
And this let's me issue notice then.
Then Ajay Kumar Mahapatra.
My notice.
All right. IN number 27 of 2017. Oh, in 2017 matter.
Generally, what happened wrongly, these Union councils are filing application for delay continuation. It is not required, man. In read petition, there is no delay. But they have filing.
They have to explain the delay. But have you explained the delay?
Yes, that was explained. I'm sorry, my lord. This is Kashyap is not. Generally, read petition, some delay is not required. Thank you very much.
The There is an application for condonation of delay. The stamp report has pointed out that there is delay of 215 days. Mr. Paril and Deputy Solicitor General submits that the
Mr. File the application first or the delay was shown?
That is, they've calculated because
No, I'm just asking. Had you filed the IA along with the writ petition? Or you filed it after the stamp reporter indicated the delay?
that I checked your my lord. Mr. Kashyap filed it.
19/1/2000.
My lord is correct.
No, this is filed same day.
Same day. That means you have preempted the stamp reporting.
That's why, yes. Wrongly it was. It is not. It should be required to be notarized, my lord. Not required. In the writ petition, there is no need to file any application for delay condonation.
And then merit report we will hear on that.
So, why don't you? We are ignoring that delay.
I am not pressing the IA. Let me keep it some of the day. We'll argue this matter.
All right. So, however, since there are view that there was no necessity, there is no such delay in filing this CMAPL. The Land Council for the petitioner seeks permission to not press the
CMPL I had not noticed. Mr. There's a division bench decision of this court that there is no delay. 1992, I think Justice Hansaria's order. So, how CMPL or not? Petition back. They don't.
Delay in filing this CMAPL accordingly. The delay is condoned. The IA is disposed of. CMAPL issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Yes. Yes, next.
But if he was edition, 1992 OLR.
This is exactly number.
The please to mind Criminal Appeal 0827 of 2024 life convict application for interim bail.
Appeal matter that 10 years custody matter co-appellant have been released on bail. Pardon to mention item number 12 of today's list. You only pay for 1 week time. Next week, Mr. Mohanty Senior Counsel will argue. Next week, any date you lost. Item 12.
No, we'll see this matter. What is this matter? What is this matter?
This is against the order of the confiscating court under the Special Courts Act. That order is there to serve copy on the State Council. I have already served. Is there?
2019 matters.
Again. Only one next Monday you lost. Defect not removed, already served the copy of the petition to the
What have you challenged? Why is it waiting for 6 years?
Instant order under Annexure 1 similarly quashed the entire proceeding. What is this Annexure 1, 2016 order?
That was remanded by the Honorable High Court to the trial court, and trial court again passed the order against the.
But thereafter, the petition is devoid of merit and stands dismissed.
Yes,
then
that is impugned.
But thereafter, it was placed to 23 to 2016 for hearing on the petition dated so and so.
That is
and
pending. Hearing is pending now, not yet disposed of.
So you're challenging the order dated 16 to 2016.
Yes, madam.
9 years, yes.
No. After 16, again it was.
What is the status of this case?
Status of the case, it is pending. The trial has.
At what stage?
Mr. Mahanti, Annexure 1.
Yes.
Isn't Annexure 1 dated 16 to 2016?
Yes, that is important, but partly hard. It is in part hard stage.
No, trial has begun means what? This petition will be maintainable now. Suppose thereafter the charge has been framed, so this order goes.
I will get this proper status.
Your main, it seems that in that order, your main argument was that this petitioner was not holding the high court office.
So this
that is why he is not supposed to face trial under that special code, right? But that was rejected, and then another petition perhaps was pending. And if in the meantime you say that trial has already commenced, trial means witnesses have been examined, so it presupposes
let me get the current status. Your lordship may fix it to next Monday. I will get the current status.
No interim order has yet been passed.
No interim order has yet.
Mr. D. Mahanti, London Counsel, appearing for the petitioner, seeks for an adjournment till next week. Stop. This CRLMP has been filed challenging the order dated 16 to 2016 passed by the London Authorized Officer Special Court Bhubaneswar in CC number 07 of 2012. From the impugned order, it appears that after dismissing the petition filed by the petitioner, the case was posted to 23 to 2016 for hearing on the petition dated 2 to 2016 and for filing so cause if any. Date status report of the CC number so and so be called for from the concerned court. File be placed before the registered judicial. During course of the day, we will send email to the concerned court and report to be furnished by Friday. That is 7th of March 2025. Place this matter on 11th March 2025. Okay.
In item 1, I pray for an adjournment.
Pardon? Mr. Panda, please wait. Let the matter be called.
Yes.
Pardon to make a mention. Item number 7, Your Lordship. I'm not feeling well. I pray for any other day.
You are for the petitioner?
Yes.
Appellant.
You will argue?
Yes.
All right. What is your name?
Rashmi Pradhan.
Okay.
R.R. Pradhan, Land Council
R.R. Pradhan.
appearing for the appellant, 6 for an adjournment. এটা IR লিখিও, IR for bail, ହେଲା? Leave this matter. You want it next week or next week? 10th of March 2025. Yeah.
Committee list item number 1.
No, I pray for an adjournment because I am ill, so I pray for an adjournment.
Have you received the copy of the paper book, Mr. Panda?
Yes, sir.
The 2016 matter.
Next week, Miller.
We are to do that, please. Mr. Mahanting appointment is in Patna. He was not appearing.
9/11/23.
Subsequently, what happened? 29 they disengage karala because he was not appearing continuously. Time phone. उसे पुणी आसिले 9-11 पुणी आसिले.
Mr. Sangramjit Panda, Land Council, appearing through virtual mode, submits that he is not well. He has received the copy of the paper book and is not well, and the matter may be taken up next week. Place this matter on 10th of March 2025.
Item 2.
May I please? Your Lordship, earlier occasion, your Lordship has been called for the custody certificate.
This bail application has been filed only for appellant number 1.
Yes, my lord.
Earlier,
the appellant number 2 has been released on bail
he has been
by your Lordship.
So it is 12 years, 4 months. So what is the bail order of appellant number 2? In which order you will release?
Order dated 3/12/2024.
You are the husband.
Yes, my lord.
Appellant 2 is
Mother-in-law in custody since 2015. So, okay.
My lord. The present appellant also inside the custody since 8/4/2015.
Examiners indicate the allegations or so on. So cause of death was due to conducted post-mortem examination. It's a burn injury, no?
Yes, my lord.
One lock from outside.
Yes, there is a lock from outside.
No, there is no evidence from lock of the house.
No evidence.
My lord, there is two doors.
Front door of the resting room was locked. That is not correct.
Two doors. Yes, my lord. There is two doors.
So, outside door was not locked.
No, my lord. Another door has not been discussed in the evidence. And my lord, there is no dying declaration and no evidence regarding the complicity of the affiliates.
Petition statement blood. Single room.
Dying declaration is not
recorded, my lord.
Asbestos house. Asbestos house with having one entrance.
Another evidence. Dying declaration has not been recorded, and there is no evidence.
Who is the person who reached there after the occurrence and supported the prosecution case? what they have seen when they reach there.
The prosecution case has been supported by the PW2, who is the informant of the case.
No, are you not following us? The person who reached the spot first, what he has seen, who is that witness after the occurrence? Because the family members might have generally stated there was marriage and there was demand of dowry, etc. But on the fateful day, since it's a case of burn injury and death took place also inside one of the room of your house, and so who are those persons who reached there?
Other witnesses who have
अरे किए कौन other माने कौन किए?
Co-villager माने मतलब किछ
We want to see those evidence. Mr. Nayak, who are those witnesses who reached at the spot? After the occurrence first, so they are the best person to say that whether the room was locked from inside. Inside ହେଇଥିବ ଯଦି, if we supposes that if there is no other road, the door, then it is a case of suicide. But if it is locked from outside, and so that is one of the also criteria. So who is that witness who has seen? କାରଣ ଆୟୁ ଆସିଲା ବେଳକୁ ତ ବହୁତ ଡେରି ହେଇଯାଇଥିବ, କାରଣ ହୁଏତ ସେମାନେ ଯଦି ଭିତରୁ ଲକ୍ ହେଇଥିବ ତାହେଲେ attempt might have also been there to broke open the door, ଏସବୁ ଟାଇପର। ତେଣୁ କୋଉ ପୋଜିସନରେ ଥିଲା ଡୋର ର ପୋଜିସନ, ସେ କଥା କିଏ କହିବେ ନା ଯୋଉମାନେ ଆସି ପହଞ୍ଚିଥିବେ ଇମିଡିଏଟଲି। ତ ସେଇ ଭଳିଆ ୱିଟନେସ କି ଏକ୍ସାମିନ ହେଇଛନ୍ତି, ପଡୋଶୀ ହୁଅନ୍ତୁ ବା ତ କବାଟ ପୋଜିସନ ଭିତରେ କିଏ କହୁଛି? Witness number? PW3. Let us see.
But in the PW3 on the previous day, the paragraph 2.
On the previous day of our day, the deceased informed us of EKA, PW3,
mother of the deceased.
Mother of the deceased, okay. Over phone that accused persons are making plan to kill her if we will not give 20,000 to them. On the next day, we got the information from one of the villagers of the accused that the accused persons have killed my deceased daughter. Getting such information, when we went to the spot, found the room in which my daughter was locked from outside. With the help of the co-villagers, lock was broken. अच्छा अरे चाबी पड़ीथिला, बाहरु चाबी पड़ीथिला। Lock was broken, and we found that the hands and legs of my daughter were tied and she was dead due to burn injury. So it's a case of homicidal death.
And there is another evidence.
ଯିଏ ଆପଣଙ୍କର ଡିସିଜ୍ଡ ର ଗୋଡ ହାତ ବନ୍ଧା ହେଇଛି, ତାକୁ ପୋଡା ହେଇଛି, ପ୍ଲସ୍ ସେ ଘର ବାହାରୁ ଚାବି ପଡିକିନି ଚାବି ହିଁ ନଥିଲା, ସେଇଥିପାଇଁ ସେମାନେ ସେ ଚାବିକୁ ଭାଙ୍ଗିଛନ୍ତି, ତାପରେ ଭିତରକୁ ପଶିକିନି ଦେଖିଲେ। ଏଇଟା ହଉଛି ତାର ଏଭିଡେନ୍ସ।
On cross examination, there is the PW2. Admitted that there is 100 to 200 people are present before their arrival.
3 ରେ ଆପଣ ୟା କହିଲେ 3 ରେ କଣ ଭାଙ୍ଗିଛନ୍ତି cross examination ରେ? What have you elicited in the cross examination to demolish the version which she has stated in the examination in chief? So totally, how many persons were residing in that house? The deceased, you and your mother, or anybody else? No. So you 3, and so mother was also convicted. She has been granted bail. So that's a different matter. She's a lady. But so far as you are concerned, after how many years of marriage this occurrence?
3 years, my lord. 3 years.
3 years.
Yes, my lord.
You are having no issue also.
I don't know.
No issue. what the IO has stated. IO is PW. Could be 20. Okay, I registered the case so and so deputation of the to this spot remain present for the inquest or so and so conducted inquest. ସେ ବିଷୟରେ କିଛି କହୁନି ସେ କାହିଁ କହ ସେ ତ ଖୋଲା ହେଇଯାଇଥିଲା ଇଏ ଯାଇ ପହଞ୍ଚିଲା ବେଳକୁ
PW3 କଥା କହୁଥିଲେ ତ on the previous day of her death, this is informed over telephone that planning to kill her. Next day, we got intimation from villagers that they have killed. I went to the spot, found that the room in which my daughter was locked from outside. Lock, broke the lock.
ସେଟା ହଉଛି ଗୋଟେ ଇମ୍ପୋର୍ଟାଣ୍ଟ ହଉଛି I found that room ହଉଛି ଶୁଣନ୍ତୁ ଏଇଟା ହଉଛି ଇମ୍ପୋର୍ଟାଣ୍ଟ legs and doors were
Locked from outside, hands and legs were tied.
And just,
Yes.
there is one evidence that there is two door to the house, and I have to need some time. And,
no, you come to IO's evidence paragraph 4. PW20 paragraph 4. It is a fact that the entire 3 rooms of the alleged house has 2 doors.
Yes.
One towards the front side and the another towards the back side. Those rooms are interconnected with each other. On my arrival at the spot, I found the front room of the closed door inside where as the back door was closed on the front side. तो से घरर 3टा रूम थिला ए जो आपनकर घर तार गोटे फ्रंट पटे बाट अछि बाहरिया पई आ गोटे पछुकु बाट अछि है ना सेटा होची फर्स्ट लाइन रो 3टा डोर बाकी कहला से जो रूम गुडाक अछि ए जो 3टा रूम रे प्रत्येक रूम होची आर सहित इंटरकनेक्टेड है ना एवं सी जेतेबेले पहुंचिला सी से तो कहूची आई फाउंड दी front door was closed from inside, whereas the back door was closed from front side. है ना तो ता संगे किसी ना ये जो रूम संगे किसी ये ना
there is 2 entrance door. And another fact is that no co-villager have been given there in their evidence that the 2 person has been locked the house who see that they locked the house or they set the fire.
No. The co-villagers have been examined and they have not supported the prosecution case. If your case is that you are not at all staying in the house, you are not aware, matter is different. But when you are staying in the house and your wife is lying dead inside a room with burn injury and he was tied, her hands were tied, legs were tied, and the room was locked from outside and the keys were also not available. Those were broke open and they made the entry and found the condition of the deceased like that. She was lying dead. So there is no question of suicidal death there. Suicidal death normally ହାତ ଗୋଡ଼ ନିଜ ବାନ୍ଧିକି କଣ ସୁଇସାଇଡ୍ କରିବ ନା କଣ ତେଣୁ ତାକୁ ବାନ୍ଧିଛନ୍ତି ହାତ ବାନ୍ଧିଛନ୍ତି ଗୋଡ଼ ବାନ୍ଧିଛନ୍ତି ତାପରେ ଏଇ ସବୁ ପୋଡ଼ା ହେଇଛି
The culprit in order and the accused person minded I have to go on through the evidence and I was sought adjournment.
sometime the land council for the appellant seeks for an adjournment. This matter. 2 weeks for this matter after 2 weeks. We commencing date. 17th date.
Yes, ma'am. Published.
I don't take.
The appellant
Okay, you have filed your V nama.
Yes, ma'am.
All right, take down. Prisoner's petition is at flag X, in which prayer has been made for engagement of Mr. J. Kamila instead of Mr. S. Roy. Stop. ଆପଣ ପାୱାର ଅଛି ତା ଦେହରେ ମିଷ୍ଟର S.K. Zafarullah, J. Kamila and others.
ଦି ଜଣ
ଦି ଜଣ have filed wakalatnama. Wakalatnama is accepted. The name of Mr. S. Roy shall not be reflected in the cause list. S. Roy means Swapnanil Roy shall not be reflected in the cause list henceforth. Yes, what is your
the appellant may not convicted under section 302 for life imprisonment and pay 5,000 in default 1 year melody. And now melody the appellant melody custody since melody more than melody 10 years melody. There are no eyewitness. Basically, only melody of circumstantial evidence melody. The appellant melody convicted melody. Paragraph 22 melody.
Given a date chart or anything when he was in custody or anything when he was arrested?
Custody melody say lekha hai. Judgment to melody already mentioned. Arrested date of arrest. 22. Melody as discussed above, the circumstances are.
No. Just first answer to the.
Yes, sir.
Where it is mentioned that since when, which date you are in custody?
Custody melody. Date of custody melody.
That would be there in the final. You are not released on bail. That's all right. But trial final form may appeal.
Will it be mentioned in the judgment?
Yes, madam.
The format mention for it also custody. 25/12/2014. 25/12/2014 ତାକୁ କିଛି ବେଲ ଯାଇନି ବୋଲି ଲେଖା ହେଇଛି କଷ୍ଟଡିରେ କାରଣ ଅର୍ଡର ସିଟ୍
କଷ୍ଟଡି ଅଛି ତ?
ହଁ 25/12/2014 ମାନେ you are in custody for more than 10 years. All right. So what is the prosecution case? Come to the judgment.
Prosecution case
paragraph 2
melody. The case of the
paragraph 2
melody. The case of the prosecution in a nutshell it is that one Jagabandhu Singh herein after referred as the informant lodged a written report on 24/12/2014 before the IIYC Berhampur police station indicating therein that on that date at the afternoon that at about 3 p.m. his father namely Dukho Singh herein after referred as deceased had been to the local weekly market to bring vegetable. After some time, Sasmita Singh and Geeta Singh are of their village returned and informed him about lying of a dead body near the jungle. Hearing such fact, he immediately rushed to the spot and identified the dead body of his father. But the head of the deceased was missing. While he inquired about the matter, could come to know that Purushottam Singh herein after referred as to the accused killed his deceased father and separated the head from the body by means of a cautery and appeared at the local police station. Prior to the occurrence, the accused, his brother and sister-in-law frequently fell in ill, for which the accused suspecting the deceased as which convened a village meeting wherein the deceased was asked to pay 500 as fine, but the deceased did not pay the same, and for that reason the accused killed the deceased on the basis of the aforesaid.
Okay, so the it, it appears that the head was completely severed from the body. So there are no eyewitnesses.
No eye.
So what are the circumstantial evidence?
Yes, for circumstances.
Where there the
Paragraph 22.
paragraph
22.
22.
As
Wait. Paragraph 22.
Page judgment page 11.
Yes.
As discussed above, those circumstances are which the accused appeared at the police station with the soft head of the deceased that and the cutlery by keeping the same in a bag, and those were seized by the IO, and the same has been duly probed by the prosecution.
So ଆପଣ ଯୋଉ ସେ deceased ର କଟା ମୁଣ୍ଡ ସହିତ ଯାଇକି ଥାନାରେ ପହଞ୍ଚିଲେ ଆଉ ଗୋଟେ ବ୍ୟାଗ ରେ କଟରୀ ମଧ୍ୟ ନେଇଥିଲେ ତାପରେ ଆଣିକିନି ଡିସିଷ୍ଟ ଏ ଯୋଉ ପୋଲିସ କୁ ଆଣିକିନି ଯୋଉଠି ଡେଡ ବଡି ପଡିଛି ସେଠି ଦେଖେଇଲେ
ସେଇ ପାରାଗ୍ରାଫ ପରେ ଲେଖା ଅଛି ଯେ already villagers are present ସେ ତଳକୁ though prior to it the same was detected by the villagers and the family members of the deceased. Second circumstances ସେ ଯୋଉଟା କହୁଛନ୍ତି ସେଇଟା ତାପରେ ଥାର୍ଡଟା ରହୁଛି ତାର ସେ ଭାଇକୁ ରିଟର୍ନ କଲା ବେଳେ ତାର ଭାଇକୁ ଏଇଟା ହଉଛି the third circumstances when one son of the deceased that PW5 was returning from Berhampur on the way met the accused, and at the time the accused told him that he took away the head of his father, and at that time PW5 saw the accused had a bag in his hand which was stained with blood. ସେଇଟା କହୁଛି ଯେ ତାର ଷ୍ଟେଟମେଣ୍ଟରେ କହୁଛି ଯେ ସେ କାହାକୁ କହି ନାହିଁ କି ଘର ଲୋକକୁ ବି ଜଣେ ନାହିଁ। 5 ର ଷ୍ଟେଟମେଣ୍ଟ ତାପରେ 4th ର ଅଛି the fourth circumstances shows that prior to the occurrence there was a village meeting convent ସେ ଯୋଉ 500 ଟଙ୍କା କଥା।
How do you explain you are appearing in the police station with the chopped head of the deceased and that weapon of offense, and you are also leading the police party to the place where the dead body, that trunk was lying there. So how did you explain that circumstance?
That already the head and available in already in PS. ସେ କହୁଛନ୍ତି ଇଏ ଯେତେବେଳେ ଇନଫର୍ମାଣ୍ଟ କହୁଛି ତା
police official must have said that you appeared with the this thing with the IO.
IO PW ସେ କହୁଛନ୍ତି ତା ଷ୍ଟେଟମେଣ୍ଟରେ 9 ମାଇଲ କହୁଛନ୍ତି ଯେ ସଡନଲି ଯାଇକି ଥାନାରେ ଯାଇକି appeal କଲା।
The accused all on a sudden appeared in the police station with a severed head with bleeding, kept in a bag, so also the bloodstained cutlery. So ତାପରେ ଇଏ ହେଲା
only there are no eyewitness and
eyewitness could assume there eyewitness तो नाहांती admittedly eyewitness नाहांती, but how did you say that
those circumstances convicted are not complete,
not clinching
for circumstances
ତା ପୂର୍ବରୁ ଆପଣ villagers ଙ୍କ ମାଗରେ complain କରିଥିଲେ ଯେ ମୋର ଏଇ my family members ସବୁ
ସେଟା 2 months prior to 2 months
ଏଇ deceased ଗୁଣି ଗାରେଡି କରିକିନି ଯୋଗୁ ଇଏ କରୁଛି, that is also the extrajudicial confession or that meeting which you have stated. So the motive part is there. Then the court head was with you. You produced it before the police station with the weapon of offense, and you also led the police party to the trunk, that spot where the beheaded dead body was lying. So
ଯେତେବେଳେ ଗଲେ ସେତେବେଳକୁ ଅଲରେଡି ଅଲଗା ସବୁ ଭିଲେଜର୍ସ ମାନେ ବି ପ୍ରେଜେଣ୍ଟ ଥିଲେ ସେ ଯୋଉ ନେଇକି ଦେଖେଇଲା ସେ ତାର ଷ୍ଟେଟମେଣ୍ଟ ସେଇଠି ସେ କହୁଛନ୍ତି ଦୋ prior to it the same was detected by the villagers and the family members of the deceased. ଆଉ ଇନଫର୍ମାଣ୍ଟର ଷ୍ଟେଟମେଣ୍ଟ ବି ସେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ କହୁଛି I suspect that the accused might have killed my father and surrendered before the police station with the
କୋଉ ଜିଲ୍ଲାର ଏସବୁ?
ବାଲେଶ୍ୱର।
ବାଲେଶ୍ୱର। ଏଇ ଟାଇପ ର ନାହିଁ ବାଲେଶ୍ୱର ପାଇଁ ଟ୍ରାଇବାଲ
ନାଇଁ ସିଂ ଟ୍ରାଇବାଲ
ଏସବୁ କେସ୍
ବ୍ରହ୍ମପୁର
ଟ୍ରାଇବାଲ ଏରିଆରେ ଏଗୁଡାକ ସବୁ ହଉଥିଲା ମାନେ
ବ୍ରହ୍ମପୁର ଟ୍ରାଇବାଲ ଏରିଆ
most of the cases of
ନୀଳଗିରି ବ୍ରହ୍ମପୁର
we can find from the other districts like Malkamgiri, Koraput ଏସବୁ ଟାଇପ ର ଏ ଟାଇପ ର ହଉଥିଲା ପୁରା ସିଭିୟର କରିକି ନେଇ ପହଞ୍ଚେଇ ଦେବେ ଥାନାରେ ମୁଣ୍ଡ ସହିତ
ବ୍ରହ୍ମପୁର ପାହାଡିଆ ଏରିଆ ସିଂ
ବ୍ରହ୍ମପୁର ମାନେ କୋଉ ବ୍ରହ୍ମପୁର?
ଗାଢ ବ୍ରହ୍ମପୁର ଯୋଉଟା କି କପ୍ତିପଦା ଉଦଳା
ନାଇଁ ଡିଷ୍ଟ୍ରିକ୍ଟ ହଉଛି ବାଲେଶ୍ୱର
ଡିଷ୍ଟ୍ରିକ୍ଟ ସେ
ବାଲେଶ୍ୱର ଇଏର ବ୍ରହ୍ମପୁର ଥାନା ଅଣ୍ଡର ନାଇଁ ମିଛ କଥା କହୁଛି
deny more than 10 years.
total deny.
Suspecting a witchcraft, you have severed the head.
That is the also କାପରେ କନଫେସନ କରିଛନ୍ତି ଏଇ ଯୋଉ କନଫେସନ
ନା ସେ ଯୋଉ କହିଲା ରାସ୍ତାରେ ଆସିଲା ବେଳକୁ ଯୋଉ ତା ପୁଅକୁ କହିଲା ସେ କଥା ସିଏ ବି କାହାକୁ କିଛି କହିନାହିଁ
PW5
ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ସେ ଯୋଉ ସେ ବି କାହାକୁ କିଛି କହିନି ତା ଷ୍ଟେଟମେଣ୍ଟ 5 ର ଷ୍ଟେଟମେଣ୍ଟ
ନାଇଁ ତା ପୂର୍ବରୁ ଯୋଉ ହେଇଥିଲା ପୂର୍ବରୁ ଗୋଟେ ମିଟିଂ ହେଇନଥିଲା କି
ସେଟା କି ସମସ୍ତେ ହଷ୍ଟେଲ କିଏ କହିନାହାନ୍ତି
3 ଜଣ ହଷ୍ଟେଲ ହେଇଛନ୍ତି
Schedule 6.
6
2 months prior to there was a village meeting convened by the accused Purushotama as his sister-in-law frequently feeling ill. In the said meeting, it was decided to treat her short expert. For that purpose, Purushotama asked the villager to contribute 500 each, but the deceased location did not pay the same. For that reason, the accused threatened the location to see the future. Therefore, we strongly suspect that the accused might have
2 ମାସ ପୂର୍ବରୁ ଗୋଟେ ମିଟିଂ ହେଇଥିଲା
cross examination in the village meeting. Number of villagers were present, those including such and such. The proceeding of the meeting was not produced in writing. My house.
So even if that gap is there, but whatever you have done on the particular day, that is very incriminating. You killed her and Shabdu ତାକୁ ହେଡକୁ ନେଇକି ଯାଇଛନ୍ତି
ସେ ବି କି ଅନ୍ୟ କେହି ବି ଦେଖିନାହାନ୍ତି ବୋଲି କହୁଥିଲେ ଲୋକ ସେଦିନ ଅସୁସ୍ଥ ଥିଲା ମାର୍କେଟ ମାନେ
no eyewitness there is an admitted case there is no eyewitness but the circumstantial evidence it's the appeal of the year 2017
that part has not been worked.
expediting hearing, the paper book has been prepared.
Yes.
No, it has not been prepared. देखो IA number 92 of 2024. This is an application for the London Council for the petitioner submitted that there is no direct evidence in this case. The case is based on circumstantial evidence, and the petitioner is in custody for more than 10 years. And the paper book has not been prepared. Therefore, there is no chance of early hearing of the appeal, and balance of convenience is in favor of the petitioner. Bail application may be favorably considered. Land Council for the state, on the other hand, oppose the prayer for bail and submitted that there are 4 strong circumstantial evidence appearing in the case, which has been discussed in paragraph number, which paragraph?
Paragraph 22.
22. Paragraph number 22 of the judgment, and the and it is a case where the appellant appeared before the police station with the court head of the deceased. So also the Kotari kept in a bag, severe head problem, severe head, and he also led the police to the spot where the trunk was lying, and before PW5 with the son of the deceased, the appellant has also made extrajudicial confession. Therefore, it should not be released on bail. Considering the submission made by the Land Council for the respective parties, the nature of circumstantial evidence available on record, and the manner in which the crime has been committed, we are not inclined to release the petitioner on bail. However, since he is in judicial custody for more than 10 years, the registry is directed to expedite the preparation of the paper book, and thereafter the matter be added to the hearing list. Stop. IA number 91 of 2024. There shall be stay of realization of fine till disposal of the jail criminal appeal.
Item 4.
Please, madam. The last occasion the state council is highly responsible.
बाहागर तो सरीगलानी काली थिला बाहागर अब कौन करी
That said that after marriage also there are other things where we can participate in other functions.
अपन cousin brother
Madam.
cousin brother बाहागर सरीगलानी तो भोजी खाଇବା ଛଡା ଆଉ କିଛି ତ କାମ ନାହିଁ ନା ଭୋଜି ବି ସରିଯିବଣି ବୋଧେ
There are other rituals and customs where we can participate.
ଆଉ କଣ କରିବ ପାର୍ଟିସିପେଟ କଣ କରିବ ବାହାଘର କାର୍ଡ ଆପଣ ଯୋଉ ଦେଇଛନ୍ତି 2nd March 2025 Sunday रे ସବୁ ଜିନିଷ ସେଇ ଦିନ ଥିଲା ମାନେ ହଳଦୀ procession ହସ୍ତଗଣ୍ଠି reception launch ଏଗୁଡାକ ସବୁ ଗୋଟିଏ ଦିନରେ ଥିଲା. It is not that some other day it was fixed for, and if that is over, then what is the necessity of your interim bail application can be considered, that's a different matter. But on this particular ground,
Consider sympathetic.
473 of 2025. There is an application for interim bail. This was the bail application where you were filed on the ground of marriage of the cousin brother of the petitioner. The learned counsel for the state, as for the order dated 25/2/2025, has obtained the written instruction from Inspector in Charge, Sadar Police Station, Barhampur, wherein it is mentioned that the cousin brother of the petitioner marriage was to be held on 2/3/2025. Since the marriage is already over, we are not inclined to grant interim bail on this ground. Accordingly, IA stands rejected. Yes.
Item 5.
Directed to take instruction.
He asked for criminal anticipation. One criminal anticipation. Apart from this case, what is that case?
Ballangir case number 258 of 2014.
What is the offense there?
No, that nothing mentioned.
Yes, what is your instruction about that case?
I have no.
You take down the number.
Ballangir case number 258 of 2014. However, the petition is involved.
Court ଲେଖାହେଇଛି
ଏ ମଝିରେ just details case record ର ଉପରୁ. However, the petition is involved in Ballangir case number 258 of 2014.
Oh, yes. The Land Council for the state has produced written instruction received from IIC, Nayapuri Police Station, Bhubaneswar, UPD, dated 17/2/2025, wherein it is mentioned that the petitioner is involved in Ballangir PS case number 258 of 2014. Let the Land Council for the state, petitioner, obtain instruction about the status of such case and file a comprehensive affidavit of this matter. 17 तारीख रखिए on 17th of March 2025. This written instruction is taken on record for seal marking.
Item 6.
Paper to accept. You are Mr. D.R. Mishra. Mr. Deepak Ranjan Mishra, Land Council, appearing for the appellant, 6 for an adjournment for 2 weeks. It will like IN number so and so. This is an application for bail. This matter will be commencing from 24/3/2025. Yes.
Item 8.
I am serving the deposition copy
to the State Council. IA number 2827 of 2024. This is an application for bail. You are in Afrin, Land Council appearing for the appellant. Handed over the deposition copies of the witnesses examined in the trial court to the Land Council for the state in court today to seek some time to go through this and place this matter. We commencing from 10th March. Next week, assume. Yes.
Item 9.
Please. Here, the appellant who was all along on bail during trial is convicted under section 302 with other minor offences. Though he has been acquitted from other minor offences. Here, the manner the prosecution case is that the informant PW12 laws in FIR that the petitioner with another co-accused threatened him to kill, and accordingly, while assaulting, the deceased came forward and objected, for which this iron crowbar pierced into his belly and he died. He was taken to the hospital, from the district hospital to the medical college hospital, but from nowhere the medical report case was reported and it is come. But however, he was taken and he is dead. On the basis of the submission of charge sheet, the present appellant, the petitioner, and the another co-accused, they were tried and found guilty. Here, my lord, if a lordship can see the brief ground of my challenge of appeal, if it is not sufficient, I will go detail. I have stated in page 4 from B. I'm just placing the grounds. For the appellant having not committed an offence, the evidence led by the prosecution is not reliable. FIR story is concocted. The scribe of the FIR is not examined. There is inordinate delay in lodging the FIR. In that with the matter, such and such. Prosecution should have thrown out and the appellant should have been acquitted. Further, the scribe of the FIR having not examined by the prosecution, when the informant says that he doesn't know who scribed the FIR, the very initiation of the prosecution is extremely doubtful. Particularly when there is no medical legal case reported when they were taken to the hospital. Rather, the PW12, the informant says that the police came to the hospital. How and in what manner it came, it is not mentioned. Mr. PW4 is an eyewitness to the offense. Yes. There, the medical doctor report opinion is that the deceased died because of the head injury. No, but please come to that. Yes. PW4 has stated. Yes. Daughter of the deceased. Daughter. Niece, not doctor. Niece. Deceased was my father, Koji. Please come to PW4. My lord. Paragraph 2, please. My lord. 3521 occurrence took place in front of our house. On that day, accused Saranga Hatti, Susanta Hatti, Nitya Hatti were discussing each other about selling of land. All of a sudden, Saranga Hatti and Susanta Hatti were quarreling with Nitya Hatti and assaulted Nitya Hatti by the means of a crowbar, which is contrary to the medical report, the postmortem report. By that time, my father was present in our house. Hearing shout, my father went there and tried to rescue Nitya Hatti from the clutches of the Saranga Hatti and Susanta Hatti. The accused Susanta Hatti caught hold of my father and Saranga Hatti stabbed my father. What is the name of the deceased? My lord? Name of the deceased. Saranga Hatti. The accused Susanta Hatti caught hold of my father and Saranga Hatti stabbed my father by means of a crowbar. This is now Saranga Hatti? My lord. No. Saranga Hatti. Not Saranga Hatti. Madhav Hatti. Deceased is Madhav Hatti. Madhav Hatti. So, accused Sushant Hatti means this appellant. How many appellants are there in this? Appellant is one, but 2 persons are convicted. That other person preferred separate criminal appeal. Might have been, I don't know. So, Sushant Hatti caught hold of the father. Saranga Hatti stabbed my father by means of crowbar, for which the belly part came out from the body, my father, fell on the ground or villagers, so on and so on. So your role is that you caught hold of the deceased and the other appellant stabbed the deceased by means of crowbar.
When he came to,
Rescue,
protect PW12, the informant.
Informant.
They were not. The prosecution is that the case is not that. To what extent it is believed by your lordship, in absence of a medical legal report from the doctor, because they went to the first hospital. So in that case, the deceased came to protect the informant PW12, and in that process, it was stabbed.
PW12. You are the injured witness. So PW12 says that first he was assaulted on the head. I so and so. Both of them abused me. Then assaulted me with a crowbar. Then I raised a noise loudly. Madhav came to the spot. Madhav means the deceased. Intervened. They also assaulted Madhav. They dealt crowbar, so and so, stabbed, so and so. This is the case.
Can I please the evidence of the doctor?
Conducted, doctor who has conducted PM?
Yes, PW16.
PW16.
Man. Complete contrary. On 4/5/2021, I was posted as Assistant Professor Bhimsar Bulla. On that day morning at about 11 a.m. on police requisition, I conducted autopsy over the dead body of this such and such. External appearance: the deceased was of average body, built in size, body length 158 cm, mouth closed, tongues inside, nail bound, such and such. External injuries: stitched, lacerated wound, size 7 by 7 cm by 0.5 cm into deep scalp depth was present over the vertex anterior posteriority. Cut wound of size 2 cm into 0.5 cm into skin depth was present over the right malar region. Step wound size 1 cm into 0.5 cm into muscle depth was present on the backside chest on the left side 11 cm below shoulder.
So many injuries were there, but the evidence is that as if he gave one piercing blow, as per the evidence of that eyewitness PW4, one Sushant got hold of Saranga stabbed my father by means of crowbar, for which the belly part. So it appears that repeated blows were given.
Yeah, but cause of death, the entire prosecution is that the blow given in the belly, which passed into the belly. But the medical opinion is that because of the head injury.
Medical injury.
From the evidence of the informant, it appears that at the behest of the police, the case has been concocted with giving certain story. Probably nobody has seen the occurrence. Because your lordship knows, the moment he was seriously injured and taken to the hospital, immediately the hospital duty bound under the law to report to the matter in medical legal case to the police. That has not been done. He was shifted to the Burla. That has not been done. And in the Burla, after death, a UD case was issued, which indicates about involvement of a third person. Investigation is neither directed nor he has been identified, brought to the record as to what is the role and what happened regarding the involvement of the third person in the UD case. So there are a lot of prosecutorial irregularities and irregularities in lodging the case. The first and foremost is that why the FIR has been lodged at a belated time.
So, Mr. Pradhan, what Mr. Mishra says that if your eyewitness is PW4, he has stated that so far as the deceased is concerned, this particular appellant caught hold of and the other stabbed the deceased by means of a crowbar on the belly. That is the specific evidence. But the manner in which the deceased has sustained the injuries on different parts of the body, including the head, that suggests that the occurrence has not taken place in the manner in which PW4 has stated. It has taken in because the head injury is one that has not stated by this eyewitness. Eyewitness is completely silent. That is the cause of death as per the. Not only that, there are also other injuries. He has stated only about one injury, that is on the abdomen. But the right molar region, there is a cut in the wound. So cut wound, obviously, it requires some other weapon. Then there is a stab wound, one, two, on the chest also there is a stab wound. On the abdomen is a stab wound. Then another stab wound is there on the chest. So that is how he is pointing out that the discrepancies between the ocular testimony and the medical evidence, so far as that main accused is concerned. But role of this petitioner is that he got hold of the what is the criminal appeal, Mr. Mishra? You are not aware about it?
No, no, man. The office
20 by 20 by 25. Whether any bail application has been moved in that case?
No.
20 by 25.
The connected criminal appeal.
Connected.
Jail criminal.
Jail criminal appeal. Achi. Sarang Bharti. He has already been admitted, right?
And UD case is registered at Bulla, which indicates about the involvement of a third person, for which there is no investigation, nothing.
No, we are not entering into all those things because it is
how frivolous a case can be. That is what I just
taken at the final stage of the hearing. So.
And the appellant during trial he was all around bail, he never misutilized. He is also not exempt. Page 109 can be seen the cross-examination of the informant. I cannot say the name of the scribe of the affair. And he is further saying, it is a fact that the affair was scribed with the help of the police. And it has been concocted a case by the prosecution at the behest, I will say, by the police, that we forced him to sell some land. He refused. That is why the occurrence, the alleged occurrence took place. That it has been explained by the stated by that witness PW12 or the land counsel for the petition. The and counsel IO PW18 may be seen. Yes. In view of the FIR not registered by the police, from the medical legal case hospital, in absence of the examination of the FIR, the scribe of the FIR. Okay. You'll also kindly see page the evidence of PW 18. We have seen those, can raise those points at the time of argument or the appeal for the purpose of the land counsel for the Mr. Land Counsel for the petitioner submits that the
initiation of the case is doubtful feature, and the evidence of the eyewitnesses are discrepant in nature. And though PW4, who is an eyewitness to the occurrence, has stated that
can I leave the court? I'm called it another court. My friend is here.
The appellant got hold of the deceased, Madhav Hati, and the other co-accused, Sarang Hati, stabbed the deceased by means of a crowbar, for which belly part came out of the body. But PW12 has stated that both the accused assaulted on the head of the deceased, and they also stabbed the crowbar at the belly of Madhav. So the Land Council further submits that in view of the nature of evidence adduced during trial, the bail application may be favorably considered. The Land Council for the state, on the other hand, opposed the prayer for bail, placed the evidence of the eyewitnesses, also the doctor, bracketed PW16, conducted post-mortem examination and noticed number of stab wounds on different parts of the body. So also lacerated wound on the head, and opined that the cause of death was on account of head injury and its complications. Considering the submission made by the Land Council for the respective parties, nature of evidence adduced, the post-mortem report finding, the role played by the petitioner in the assault of the deceased, we are not inclined to release the petitioner on bail. Accordingly, the bail application stands rejected. Yes.
Item 10.
Last order of Lordship, kindly see 20th February 25.
I have obtained the report. Yes. Yes, 4 years from. So, what is the case against you?
Allegation is that, my lord, there is eyewitness to the eyewitnesses. 4 eyewitnesses are there. Out of 4, my lord, one Bhagavan Jena turned hostile, and Gura Jena turned hostile, and Gajendra Pulai not examined.
Who has supported you? Just tell us.
Panu PW1, my lord.
PW1 supported.
Supported, my lord. And in cross examination, para 6.
Who is the doctor who conducted?
Doctor, my lord, PW13.
This is your mother?
Yes, yes. That the appellant is the son, deceased is the mother, and eyewitness is the father. And so far as the para 6, your lordship, kindly see cross examination.
Who has given evidence against you? That informant is you?
Informant, my lord.
Your father?
Father.
What he has stated? That
he has
assaulted by means of an iron rod.
Iron rod. And he also assaulted me. Out of fear, I left the spot. The accused assaulted the deceased due to.
PW 2 and 3 have also stated that you dragged her and took her from the house.
No, they are not the eyewitness.
No, but they have stated you took her
In
and
process,
dragged her from the house.
they are not there. Para 6. Cross examination. My dwelling house is 2-room Pakka house, and there is a thatched house in the Bari land. There was cold time at the time of occurrence. At the time of occurrence, at the time of incident, I was sleeping on the first room, Dandagara of Pakka house. Both the front and the back doors of the Pakka house was closed. I took rest after taking food at about 6:30 p.m. On that date, the back door was open. On that date, my wife was sleeping in a room in the Bari land. I cannot say if the door of the room where my wife was sleeping was closed or not. On the next room, the accused and his wife were sleeping on that day. On hearing her I reached in the room where the deceased was sleeping. When I reached my deceased wife was lying with full of blood, and when I lifted her from the ground, she was dead.
So as it appears, or totally there are 3 rooms.
Yes, ma'am.
There are 2 dwelling house room. One is in the backyard, and
Yes.
that backyard room is a thatched house. In that backyard room, the deceased and the appellant were sleeping.
Yes.
And this eyewitness was sleeping in the first room.
First room.
That is Dandagara.
I-
Though in the chief examination he has stated that I saw the appellant assaulted the deceased by means of an iron rod, but in the cross-examination he stated that while he was sleeping, he heard holla, and when he reached the room, he found that the deceased wife was lying in a pool of blood.
Yes.
And what your submission is that, and the weapon of assault was also lying at this spot. That is in paragraph 7. That means your submission is that this man is an eyewitness to the occurrence. The father is a doubtful feature.
Yes. Considering that, you will also call for the antecedent and
What has come in the antecedent? No antecedent.
No. One into the PW13, your lordship.
For the evidence of that eyewitness, the eyewitness gives a Babaji.
Panukulate. One. Yes.
I'm not sustained.
No.
My lord. Either one was stated that I was also assaulted by two blast. My lord. And has he sustained any injury? କାରଣ ଆପଣଙ୍କର chief examination ହଉଛି accused assaulted not only my deceased wife but also assaulted me in the chief examination. So whether he has sustained any injury, because not only he is harping on that cross examination which he has elicited to show that the chance of PW1 seeing the actual assault on the deceased is very doubtful because he was sleeping at the holla and went there, and when he went there, at that time the deceased was sleeping in the backyard in a thatched room. He found the lady was lying with bleeding injury, and the crowbar was lying there. So this is one of the features which would show that he has not seen the actual assault. Second thing is that even though he has stated that I was also assaulted when the deceased was assaulted, you have not proved any medical evidence to show that in fact he was also assaulted. In fact, if you would have proved that, that would have shown that yes, his presence would not have been disputed because he's an injured witness. But is there any evidence to show that he sustained any injury, sent to any hospital, or any uh, evidence of the doctor is there?
Because the witnesses who have stated that the accused assaulted his mother, and when the informant went to call these neighbors and they came, then the accused threw the that steel rod there and ran away. They had stated that before the police, but in court they have not stated.
No, okay, sir. Support करना. କାରଣ ଆଇଓ ମଧ୍ୟ କହୁନି ଯେ ସିଏ PW1 କୁ ମେଡିକାଲ ଏକ୍ସାମିନେସନ ପାଇଁ ପଠେଇଲା ତ ଓବିୟସଲି ଇଞ୍ଜୁରି ଦେଖିଥିଲେ ପଠେଇଥାନ୍ତା ସେ ମଧ୍ୟ ଆପଣଙ୍କର PW1 ର ଏଭିଡେନ୍ସ ହିଁ ନାହିଁ ସରି ଆଇଓ ର ଏଭିଡେନ୍ସ ନାହିଁ ଆଇଓ ର ଏଭିଡେନ୍ସ ଓନ୍ଲି ହଉଛି ଯେ ଡେଡ୍ ବଡି କୁ ପଠା ହେଲା ପୋଷ୍ଟମର୍ଟମ ପାଇଁ. So in two ways the evidence of PW1 as an eyewitness creates doubt according to Mr. Sahu that his version as an eyewitness to the occurrence is doubtful on these two grounds. Apart from the thing that the property dispute, the case has been, that is his case, and you have also stated that there was property dispute. The witness has also stated that.
Who is this PW2?
Is the sister. Sister of the accused.
No, she is not there.
Daughter of the informant.
She arrived later.
Only paragraph 5 re. I heard about the incident.
That's the paragraph. Arrived next day.
ଆଉ ବାକି ଯୋଉ ସାକ୍ଷୀ ଗୁଡାକ ବି ରେଲେଭେଣ୍ଟ ନୁହଁ ତ ମେନଲି ଆଉ ସବୁ ହୋଷ୍ଟାଇଲ ମଧ୍ୟ ହେଇଯାଇଛନ୍ତି PW4
ଯୋଉମାନେ ଦେଖିଛନ୍ତି
ଗାଁ ଲୋକ so entire evidence case based is on the two witness. One is that doctor who conducted the postmortem examination and PW1. Mainly evidence based could be concluded.
You're in custody since when?
Since 21/1/2021.
4 years ago.
4 years, 1 month.
4 years, 1 month. P123 of 2024, there is an application for bail. As per the order dated 20/2/2025, the Land Council for the state has produced the custody certificate of the petitioner received from IIC Case Nagar Police Station, Ganjam, which shows that the petitioner has remained in custody for more than 4 years. The custody certificate is taken on record. Mr. Sahoo Land Counsel for the petitioner submits that the petitioner is the son of the deceased and the main evidence, the star witness in this case is none else than PW1, who is the informant in the case and father of the appellant, father of the petitioner. And in the examination in chief, though PW1 has stated that the petitioner assaulted to the deceased by means of an iron rod and also assaulted him, bracket PW1, for which he left the spot out of fear. But there is no medical evidence to support that PW1 has been sent for any medical examination, and no medical document has been also proved to substantiate any assault on PW1. He further submits that the cross-examination of PW1 would reveal that he was sleeping on the first room, bracket Dandaghara of the Pakka house, after taking his food when he heard Halla, and when he reached the room where the deceased was sleeping in the backside, he found the deceased was lying in a pool of blood, dead, and one iron rod was lying at the spot. It is the contention of the learned counsel for the petitioner that the evidence which has been elicited in the cross-examination creates doubt about PW1 as an eyewitness to the occurrence. He further submits that there are good chances of success in the appeal and balance of convenience is in favor of the petitioner. And since this is an appeal of the year 2024, there is no chance of early hearing. Therefore, the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail and place the evidence of PW1, so also PW13, the doctors who conducted post-mortem examination and opined that the cause of death was due to severe cerebral hemorrhage due to injury by blunt force of the over the head. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced during trial, the relationship between the petitioner and the deceased, the period already undergone by the petitioner in judicial custody, and absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail, subject to condition that he shall not indulge in any criminal activities. And he shall not
Monopoly. House of PW1. କାହିଁକିନା ବାହାରେ ରହୁଥିଲା ସେ ଘରକୁ ଭିଲେଜ ବନାପଲ୍ଲି the house of
We shall not enter to village Bannapalli.
Please Kabi
Under Kavi Surjanagar police station. Principal level shall not try to come in contact with the informant.
Right.
Yes.
Stay relation fine.
Stay relation.
Public.
Item 11.
Item 11, may I please, my lords. My lords, the present appellant has been convicted under section 376(3), 376(DA), 6 of POCSO, 450, and my lord 32V of SCST Act, my lord. So, plus the operating portion of that is in
Notice is sufficient.
My lord, notice has been sufficient, and my learned brother is appearing for the informant.
Yes. So you have received the deposition copies.
Yes, sir. Paperwork.
Paperwork has been prepared.
Yes, sir.
Yes. So,
my lord, the present petitioner is in custody since 21/1/2021. And from the date of arrest, my lord, he is in custody, my lords. My lord, so far as the case of the prosecution is that the present petitioner, along with one, my lord, Manoj.
Who is that victim?
My lord, victim is PW1, my lord.
ये लाइव स्ट्रीमिंग बंद कर दीजिए